We're opening the October 11th, 2022 meeting of the State Board of Equalization. I'm Bob Schiffmacher. With us currently, we've got Al Plank, member of the board, Tim Morris, member of the board, and myself. Tyree Gray apparently is on another call and will join us momentarily. At this point in the meeting, I will ask for public comment at the beginning. I'll also offer an opportunity for public comment at the end of the meeting. So is there any public comment?
If anybody on the Zoom has public comment, please hit *9 if you're on the telephone, or raise your hand in the right-hand corner. I don't see any at this time.
Hearing none, the next step in the process is to set forth the rules regarding the operation of the meeting. I have a list of items that we need to adhere to. Number one, do not talk when members of the State Board of Equalization are talking. Number two, do not speak unless you have permission from the chairman. Number three, when the chairman gives you permission to speak to the members of the board, not to the opposing party or to anyone else. Do not raise your voice or act in a hostile or aggressive manner. Do not speak down to, demean, or harass anyone in the proceeding or in the meeting. If you want to move from behind the table, ask the chairman for permission to do so. Handouts such as evidence must be handed to the State Board coordinator for delivery to the State Board members. Do not interrupt anyone. Do not argue with the chairman, State Board members, or the parties to the hearing. And do not speak, make noise, or gesture with your body when someone else is speaking. Also in attendance are Michelle Briggs, Chief Deputy Attorney General for the state of Nevada, and she functions as the attorney for the State Board. And Jeffrey Mitchell, Deputy Director of Nevada Department of Taxation. And Jeff, you would introduce your staff. We can get rolling.
Thank you, Mr. Chairman. Jeff Mitchell, as mentioned for the record, and assisting with staff today is Hector Sepulveda and Christina Griffith, as well as Miss Kathy Jackson, who is our court reporter today. Also as staff assisting, and I would like to introduce is Miss Yvonne Navarez-Goodson and Miss Kelly Langley. And I will turn it back to you.
Okay, Jeff, we do have a quorum with 3 members. At this point, we're hoping that Tyree will join us, but at this point, we have, I believe, on the agenda several stipulated values, and with the short board, I think we'd like to hear those and get that administrative detail out of the way. So if you would call those cases.
Yes, Mr. Chairman. If perhaps first I could have Miss Michelle Briggs administer the oath to any that may testify.
Thank you, Mr. Chair, and good morning. If anyone would like to testify today, if you could raise your right hand. And do you swear or affirm that the testimony you will give today in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you.
Thank you, Michelle.
Under agenda item C for possible action, direct appeals of personal property placed on the unsecured roll after December 15th pursuant to NRS 361.360 sub 3. We have case number 22-135, 22-136, 22-137, and 22-138. The proper notice of hearing can be found on page 11 of each of those appeal files. And with these appeal files, the petitioner and the respondent have reached a stipulation, which can be found on page 9 of those packets. And that stipulation is for consideration in front of the board at this time.
Thank you. With the stipulation, it is the option of the parties to present any testimony or discussion of the case. The discussion since it's a stipulated value, will probably not have an impact on the ultimate outcome of the hearing unless there's some controversy. Do any of the parties care to address the board?
No.
Hearing none, I'll close the hearing and ask for any discussion from the board and or a motion.
Yes, Mr. Chairman, I'll make a motion that we accept the stipulated value on case number 22-135, Peppermill Casino, the personal property. That's my motion.
Tim, would you care to add we've called all 4 cases. If you would care to add those case numbers, we'll accept all of those values.
Okay, I'm sorry. I thought he only called the first one. So yeah, okay. Case included in the motion will be case 22-136, case 22-137, and case 22-138, which are all personal property affecting the Peppermill Casino and Reno. I make a motion, we accept the stipulated values.
Any discussion or a second?
I'll second with comment. I just wanted to reiterate our appreciation of the parties able to come together and reach these agreements so they're just less contentious and a good public service. But I'll second.
Okay. I have a motion and a second. All in favor indicate by saying aye.
Aye.
Any opposed? Motion carries. Jeff, I would prefer to hear the next 2 cases with the full board. What are your thoughts and recommendation?
I agree. Perhaps a quick 15-minute recess to see if Mr. Gray can join us. But if unable to join us as we're proceeding through the day, perhaps it is best to proceed onward.
Okay.
This is Christina for the record. He just sent me a message saying he is double booked and will be on around 10.
Oh, wow.
Okay, well, in that case, I'm unwilling to hold the meeting in abeyance until 10. At this point, Jeff, if you would call the next case.
Will do. For possible action under agenda item D, appeals from action of a county board of equalization pursuant to NRS 361.400 for the 2021-2022 unsecured roll. And
Do we have?
Mr. Morris, perhaps if I could ask you to mute your microphone, I think we're getting a little bit of feedback. Thank you, and I apologize for the inconvenience there. So for possible action under agenda item D is case number 22-119. Proper notice of hearing can be found on page 203. The petitioner is Oakmont Corporation and the respondent is the Washoe County Assessor. If I may recollect your memories, this is a continuation of a case that was originally called June 29th at our regular hearing of the State Board of Equalization. With that, upon agreement of both the petitioner and the respondent, it was asked that the Department of Taxation survey county assessors in regards to the application of the regulation that had come forth. With that, there is the county surveys and the response for your consideration, as well as Oakmont's response to the surveys. Those are separate files from the record, and I believe that all board members have received that. I believe it would be appropriate to both have comments from the petitioner and the respondent to review the case for the board, as well as to speak to the additional information that has been brought forward upon the state board's request.
Thank you. So at this point, we'll turn to the assessor's office for a brief introduction regarding the property and then turn it over to the petitioner for their comments and discussion. Is that the appropriate program? Washoe County.
Justin Taylor for the record. Thank you, Mr. Chair, members of the board. We are discussing for the 21-22 tax year, an aircraft, a 2010 Gulfstream model G40 tail number 43AD.
Thank you. Is the representative of the petitioner available either in person or by Zoom?
Amy, you can go ahead and unmute yourself.
Easier said than done. Can you hear me?
Yes.
Should I say as an attendee or should I join as a panelist?
The panelist will allow you to turn your video on.
Oh,
Okay, and then unmute yourself. There we go.
sorry about that.
Okay, Amy, this is your opportunity to present kind of a synopsis of what we discussed or what your interpretation of our discussion last meeting and introduction of new evidence.
Right. So I think from our last meeting, the petitioner was really asking to be valued fairly for the presence of time that the plane was in Nevada. So Oakmont Corporation acquired a plane. The plane was acquired mid-year for the lien date and was not disputing that the plane wasn't going to have habitual situs in Nevada, but was disputing the way it was valued for that first date, which was as of the July 1st, 2021 lien date. So the assessor's office was valuing it as though it had been in the jurisdiction for 365 days, but it was only in the jurisdiction for 6 nights. I believe we had some considerable discussion about how other counties were handling it, whether the jurisdiction was going to be double taxing the plane and what the commercial domicile of the plane was. So we went back to the client to see if we could get some additional information, and I put a response in there and would just like to summarize some of that information. So one of the questions that came up was, could this plane be subject to double assessment if Nevada assessed it for the period of July 1st, 2020 through June 30, 2021? And I had mentioned that the plane was going to be hangared in Nevada and that the commercial domicile of the plane was in California, and the rest of the time it was going to be on the Van Nuys Airport. So we did learn from the petitioner that they had reported their property in California as of the 1/1/2022 lien date. And that represents the period from January 1st, 2021 through December 31st, 2021. And that the LA County had issued them a notice of value for 100% of the value of the plane for the entire calendar year of 2021. So if this assessment
2021 or 2022?
It's the 2021 calendar year, which is reflective as of the 1/1/2022 lien date.
Okay.
And so if this assessment stands with Nevada, then my client will be double assessed for that period of time from January 1st, 2021 through June 30th, 2021. The second piece of information was to see if we could obtain flight logs that were pre-purchased, and the purchase date was February 21st, 2021. My client went back to the seller, and flight logs from Hong Kong are referred to as technical logs, and they were provided.
Amy, you've frozen.
Uh-oh. My last name is Freeze. Can you hear me?
Yes.
Go back about 5 seconds. We missed just the last couple of words.
5 seconds. Yeah. So the next piece of information was to try to obtain flight logs that were pre-purchased, and the purchase date was February of 2021. The flight logs are referred to as technical logs, and they were provided from Michael Chan, who's the lead flight manager of TAG Aviation in Hong Kong.
Ms. Freeze?
Yeah.
I apologize.
Am I freezing again? Now you guys froze. Hello? Can you hear me? I can see, Al, I can see you moving, so you're not frozen.
Yeah, no, you and I are about the only ones that are alive and well, I think. So, Tim's
Tim's
good.
alive too. Kathy's alive. I don't know who all you, who everybody is, but
The room that's broke, like they're
is the
having.
frozen gone? Is the
Yeah.
room is gone? I guess I'll wait for it to come back alive.
Yeah, now they're completely gone.
Yeah, I just don't think we can use your last name anymore.
Yeah. I used to say Foster Freeze. It's Dutch.
Are are we
Hi.
active or is everybody still frozen?
You guys were the only ones frozen, so I think we're good.
Mhm.
Should I continue on? Uh-oh.
They look frozen again.
We've taken a 10-minute recess while we speak with IT because our Zoom connection is somewhat erratic. And so we're going to try to get this stabilized and then come back to the meeting. So you've got roughly 10 minutes. Hey, Al, can you wave your hand? Okay, just make sure that everybody's here. Is Tim? There he is. Okay, are we good? So we'll reopen the meeting. Ms. Freeze, I apologize for the delay. We got about the first 3 or 4 minutes, but after that, the connection was pretty sketchy. So if you would like to either start over or pick up in the early middle, that'd be fine.
Thank you. Can you hear me okay?
Yes.
All right, I'm just going to re-summarize. So the basic issue is that my client, Oakmont Corporation, acquired a plane in February of 2021. And from the period of February 2021 through July 1st, it was in the state of Nevada for 6 nights. The county assessor is valuing it as though it was in the state for 365 nights. So it's including a period of time when the plane wasn't in the state. And can you hear me okay? Nope, froze
Yes.
again. And a period of time prior to my client actually having ownership. Some of the questions that came out of the meeting last time were to confirm if there was double assessment that was occurring, to see if we could obtain flight logs for the period prior to my client owning the plane in February 2021. So what we supplied as additional information was a notice of assessment from the state of California and LA County for the jurisdiction where the company is having, the plane is being stationed on the hangar, and also where the commercial domicile is. And it's for the period January 1st, 2021 through December 31st, 2021, which is what period is used to report the 2022 property tax statement. And so it shows, and this is a correction, by the way, to my heading here, because it shows a double assessment for the period of January 1st through June 30th. So we are proposing that Oakmont right now is currently being double taxed for that period. And one of the reasons why Oakmont is also requesting to be valued under the allocation method that's part of NAC 361.1434. And that's shown in TAI 6, I believe is what it's referenced. And then my client also reached out to the seller for flight logs that were pre-purchased of February of 2021, and the flight logs are referred to as technical logs in Hong Kong, and they were provided from Michael Chan, who is the lead fleet manager of TAG Aviation, and they indicate that the plane was parked in Hong Kong from March of 2020 through November of 2020. And then in December, the plane flew to Georgia via Tokyo and Alaska, which was all part of the purchase and sale agreement to accomplish the purchase inspections and the test flights that were incurred in January of 2021. And then the plane was parked in Illinois until the official closing in February. And I've summarized that in table 1, and I want to apologize to the board and to the county and to Christina, because when I initially provided it, I think it was a little bit convoluted in how it was attached. So I did summarize it in table 1 so you could see the SRP numbers and then the flight dates, the technical log, and then I also had the appeal documentation number. So it's not necessarily in order in terms of how it was attached, but it is in order in table 1. So once again, this flight log shows that it was parked in Hong Kong from March of 2020 to November, and then it began its flight from December through January as part of the purchase and sale agreement. We also provided aircraft registration information, noting that the aircraft was not registered with the U.S. Federal Aviation. It was a Hong Kong registered aircraft prior to the purchase, and the aircraft was released from the Hong Kong registry, noting that the change in the Hong Kong registration number to a U.S. registration number, along with the U.S. FAA granting it standard airworthiness. So you can see also in the attachment that there's a registry noting that it's being released, which is in TAI 31. There's a registration change from Hong Kong to the US, which is in TAI 33. And then there's standard airworthiness certificate that was issued in June of 2021. And then there's a flight log, which shows the conformity flight to get the standard airworthiness. And there's also a flight log showing that it leaving Illinois for Nevada. So I guess in terms of information, my client is requesting to be valued and allocated under 361.1436. And so one of the requirements is to provide substantial information. And so I think we believe that we've provided the purchase and sale agreement, the warranty bill of sale, the flight logs for the period of time that they owned it, which was February through July. We've provided flight logs after the lien date from July through November, indicating the intent is consistent through the next year, that fiscal year that covers the next lien date. And we've now supplied the flight logs pre-ownership from March of 2020 through February. And we've also supplied a notice of value, which indicates that California is assessing it in their state and looking to assess it as though the commercial domicile of the company is in California. I did review some of the information that came in from the county. I thought it was a little bit inconsistent, but not necessarily surprising given some of the differences in the information that the county received and that we received. And I thought some of the inconsistencies was just maybe reflective of how much activity or how often this situation occurs. I thought the most comprehensive response was from Clark County, which I mentioned in my previous hearing, which we had relied upon, and we would concur with Clark County's, interpretation of the statute and their application of it. And so, I mean, as we stated in the previous hearing, the petitioner is not asserting that the aircraft isn't taxable. The petitioner is just indicating its intent for the aircraft to split its time between California and Nevada and asking to be valued fairly under the code for the 6 nights that it was in Nevada. And then also cautioning that when you look at, the LCP Rule 001-2, it talks about due process clause and the commerce clause, and the concern about, reaching through other jurisdictions and not allowing for an allocation because there could be a double taxation. So I guess in summary, we're still asking for an allocation of the value. And once again, we believe that we provide, sufficient information to demonstrate that the plane was not in Nevada for the full 365 days of the year, and that the company's commercial domicile is in California, and that their intent is really to split the time between California and Nevada, and they'd like the value to reflect that fairly.
Thank you, board. Any questions? Amy, have you filed a similar appeal in California or does California do an allocation similar to Nevada's for transient property?
California does do an allocation, and they initially valued the plane at 100%. The company themselves handled discussions informally, and a revised assessment, it just came out. I didn't introduce it because I thought it was after the deadline, reduced the value for the time that it's allowed in Nevada. I can tell you, though, that they picked up the time prior to the plane being owned and the time that it was in Hong Kong. So we will be recommending to the company to file a formal appeal by November 30th, which is the deadline for the 2022 lien day, which reflects the 2021 calendar year.
Okay, thank you. Go ahead.
So the initial assessment was 100%, and then the company themselves was able to reduce it by the period of time that it was in Nevada. I have that. I haven't submitted it though, but I have it.
Yeah, that because the claim at this point is double taxation, I was just curious to hear whether California was going to tax it 100% of the year or not. And it appears that there is ongoing discussion regarding a reduced allocation to more accurately reflect the domicile of the aircraft.
Correct. They reduced it for the period of time that the plane is in Nevada. They did not reduce it for the period of time that the plane was in Hong Kong, to which we are going to be recommending they file an appeal to address that issue.
Do you recall whether California has an audit procedure at the end of the taxable year that allows retrospective look at the actual behavior of the aircraft?
California has a mandatory 4-year audit, and there's some guidelines about whom is picked, but the period of time right now that we're talking about is still eligible for review just under the regular appeal, which can be filed by November 30th. If they miss that appeal deadline, then it's possible that the plane could be picked for audit. There's a statute of limitations, which is 4 years. So the county would have, up to 4 years basically to pick the plane for audit, and then they would typically audit it in 4 years, like 4 years at a time, like 4 lien dates.
Okay, thank you. Board, any further questions? Hearing none. Washoe County?
Pardon me, Justin Taylor with Washoe County.
Thank you, Justin.
Washoe County stands on its idea that this aircraft did not establish taxable situs in another jurisdiction prior to July 1. It was out of the county. We do have flight logs, but taxable jurisdiction pursuant to Section 18 in the in LCB, I don't think this gives us exactly what we need. You know, the aircraft was purchased, it was brought in, it spent time down getting refurbished, which is not taxable situs. An aircraft that's not flyable due to maintenance and overhauls is not taxable. It doesn't establish taxable situs, in our opinion. And with the survey that went out, we appreciate all the other counties that got in. And I agree with Amy. Clark County has the most comprehensive answer. And in Clark County's number 4 says with the hypothetical situation sent out by the state, an aircraft is new to the role. I'll let you guys read that number 4.
I'm sorry, what page are we on?
I believe it's 10 of the county surveys. Page 10 of the county surveys, is that
Yes.
correct?
Yep.
Okay, you go ahead.
Okay, and it asks, what's the allocation to your county? Based on the information provided above, I would not allocate this aircraft. It would be 100% within what Clark County. With the evidence required by LCB file number R00127 subsection 18, there are no grounds for apportionment value.
Go ahead and read number B in that section. It reads, the flight logs have been shared with you showing overnights in various jurisdictions between July 1st, 2020 and June 30th, 2021. But no tax bills have been provided. Do you adjust? And the answer is there.
If it has sat somewhere long enough to acquire taxable situs, this is not verbatim, in one of those locations, I would apportion its value.
Mm-hmm.
It's where the county, where Washoe stands, is it never sat anywhere long enough to gain taxable situs outside of Nevada.
Well, it does say here in the second paragraph that R001-20 does not require those other jurisdictions to actually tax the aircraft, but rather that the aircraft have enough presence in those jurisdictions to have acquired taxable situs.
Correct.
So during during that fiscal year, the July 2020 through June 2021, the aircraft spent the vast majority of its time, or not the vast majority, but the majority of its time in Hong Kong, and other time in other jurisdictions.
Once acquired by.
Right. So, so during that tax year, if we're taxing the personal property, not the ownership, they track the aircraft's location. During that fiscal year, it did not spend the majority of its time in the U.S. or in Nevada. Is that correct?
It spent
some time.
6 days roughly.
6 days. Okay, go ahead. I apologize. Are you?
Yeah, so the 6 days that it did spend here prior, establishes taxable situs in Nevada with our lien date being July 1. But Washoe County does not believe that taxable situs was established elsewhere with the plan undergoing maintenance once acquired. So it's absolutely impossible, in my opinion, to prorate based on what we've been given.
The fact
that this is being double assessed in California for the 2022 tax year, we've processed Oakmont for the upcoming fiscal year tax year based on proration that they've given us on their flight logs, and done so accordingly. It's our opinion that they did not obtain taxable situs elsewhere.
If I may, Mr. Chairman, for the record, Tony Lopez, personal property coordinator for Washoe County. We do also understand that they were billed for lien date 2022, but the fact of the matter is that our assessment came for July 1, 2021. And so technically, whatever it is that they have to arrange with California should be based off of what we've already assessed them. And so for us, because, basically reiterating what Justin is saying, to us, they didn't establish taxable situs elsewhere. And based on how we have processed all other accounts that are like this, it was assessed for 100%. For that first year, we just do not take allocation unless they're able to prove to us that they had taxable situs elsewhere. And so what I'm trying to get at is that the tax bill that they received and the assessment they received for January of 2022, that's their lien date. Our lien date was July 1 of 2021. The assessment had already been made, so whatever arrangement needs to be made to allocate for California, that's kind of a separate issue, I guess is what I'm trying to get at.
So just for clarification, the collection of information from the tax year prior to the lien date is an attempt to project the behavior of the aircraft during the taxable year in the future.
Correct.
So the theory being that over time, you will be taxed for the current year using a projection of its behavior from the prior year based upon the information that's collected for the prior year. That will be applied to the current year, 21, 22. 22, 23 will be projected, its behavior will be projected based upon its behavior in 21, 22, correct?
Correct.
So if we're looking at the aircraft from 20 to 21, June 20 to June 21, and it had been under consistent ownership, if we take the ownership out of the equation, out of 365 days in the year prior to our tax year, it was in the state for 6 days.
It was in the state, that's correct.
For 6 days, which is enough to establish taxable situs. But personally have a difficult time leaping from 6 days during a calendar year if we're taxing the property and not the ownership, leaping from 6 days to 100% for the coming year using the behavior of the aircraft in 2020 through 2021 to predict its behavior being its location from 21 to 22. I agree that it's developed taxable situs. I am having a difficult time making the leap that 6 days represents 100% allocation. We have demonstrable evidence that the aircraft was elsewhere. The LCB does not require that those other jurisdictions tax the property, just that it's located there and could develop taxable situs. I don't know what the tax laws on aircraft in Hong Kong are, but it spent roughly half the year there. I don't know what the tax laws are regarding an aircraft in Illinois down for repairs or maintenance, but it was spent a substantial amount of time there as well. Whether those jurisdictions chose to tax the property or not is in my view of secondary importance. Just because the property is not taxed in those other jurisdictions does not necessarily mean that Washoe County or Clark County or some of the other counties can kind of hoover up all of the tax revenue for, just because Hong Kong leaves it on the table doesn't mean that Nevada can scoop that up, in my view. Board, any thoughts or comments, questions? Are you guys done presenting?
I just had one last comment.
Please.
And I just wanted to see if I could ask. I know that you, Jeff was good enough to send these out for all the counties to kind of fill out. And it looks like every county interprets it in their own way somewhat.
Absolutely.
And so I wanted to get the opinion of Jeff over everything that was actually presented to us that was filled out on what is the correct method, what the correct approach based on all the responses.
Did you raise your hand?
And if I can add in an attempt to project going forward.
Right.
Legitimate.
Yeah, absolutely.
With a business that has other aircraft here that spend the majority of their ground time here.
Because we really want to remain fair and equitable.
Absolutely.
And if we have to change process, that's fine.
Well, I think that this represents a unique situation and not one, and that's, I think, why there was such inconsistency with the responses. Not only does Elko and Nye County see this issue infrequently, but this represents, even for Washoe County and Clark County, a unique situation that, an aircraft, I'm going to guess, is held by an owner for multiple years. And, so the taxable differences, the allocation differences kind of even out over time. But this one, if this property if this aircraft had arrived in Nevada in July or August 21, the answer to the question might have been different. But because it spent the 6 days in the prior tax year here, I don't think that that's a good predictor of its behavior in the future, but I don't think it's an indication. I don't think it's a predictor of 100% either. So, but that's my view. Do you have?
I didn't mean to interrupt.
No, please. Do you have any further presentation? And I'll turn it back over to Jeff to see if he was able to decipher any consistency.
I think we're good. Thank you.
Okay.
Thank you, Mr. Chairman. Jeff Mitchell for the record. That's a little bit of a difficult question because my role as Deputy Director of Local Government Services, where I provide advice and guidance to the county assessors on equitability and fairness and establishing the regulation and statutes, is a little bit different than my role as acting secretary to the State Board of Equalization, where I need to make sure the State Board is providing procedurally the avenues for both parties to present their cases and arguments. In regards to this regulation, it does give deference to the assessor to look at the evidence that is in front of it, to try to, as you said, look at past information to predict future establishment of situs within the county at that time. With that, the assessor did look at the information available to it and did establish that taxable situs of what it believed would be the allocation going forward. And the board is receiving evidence of both whether or not it agrees with Washoe County that enough evidence was provided to make that decision and uphold that decision. Was that a real squirrely answer?
That was, yes. So basically, if I've interpreted your comments correctly, Washoe County used the information they had and drew a conclusion. There was nothing in any of the responses to either affirm or reject that conclusion. And so it's left to the state board to decipher the information and try to draw an equitable solution.
Yeah, unfortunately, I can't introduce my opinion as evidence in this particular case.
Okay. Amy, would you like to offer a closing argument and answer any further questions?
Sure. I mean, I have some concerns over what the county has said, because initially the way this came about is, we reached out and had a verbal conversation and were told there was no filing obligation because the plane had only had 6 nights and wasn't there as a lien date. And then when the county discovered it through, I think, some reports that were filed by the aviation company that owned the hangar, my client filed the rendition that was required. And then the county asked for flight logs prior to the July 1st lien date, which we provided. And then the county asked for flight logs after the lien date, which we provided. And then the county itself even suggested and proposed an allocated value, but then upon further discussion, rescinded that offer and valued it as though it was their 365 days. And their response was that they had reached out to other counties and needed to be consistent with how other counties had handled it. So I didn't really get the impression that the county had established precedents for how they did it. Otherwise, I wouldn't have had this confusion about filing the return, providing situs issues prior to the lien date and afterwards. And so, I think the most comprehensive answer is Washoe County's. It's what we would agree with. I also want to remind the board that this company's commercial domicile is in California. So typically under the home port doctrine, if the period of time that you can't establish situs in a jurisdiction would get sourced back to California, which is what California did. So California is valuing the plane for the period of time that it wasn't in Nevada. And then there's also a court case in California, which I didn't introduce, but talks about the due commerce clause and how, the states should not have the authority to reach out to the foreign countries to establish situs back or to tax it for a period of time that it was in the foreign country, because it violates the federal constitution and the commerce clause. So, my client agrees that it has situs in Nevada. It intends to habitually park the plane there, just wants to be valued fairly. Thank you.
Thank you. Board, any questions? Tim, your hand's raised.
You're on mute, Tim. Sorry. Oh.
Tim, you're muted.
Can you hear me now?
Yes.
What was the purchase price of the plane?
You always have such relevant questions. I don't have that off the top of my head.
Approximately $10 million.
Thank you.
And the Washoe County assessor, what's the total value that you placed on a plane?
The total taxable was 11,877,408. Assessed value was 4,157,092.
The discrepancy being the cost of maintenance and upgrades
Correct.
that were included in the cost basis.
So the 4 million that the petitioner's asking for is the assessed value.
That's
Is
correct.
that right, Amy?
Correct.
I think that the plane should be valued based on the 6 days it was in Nevada. I don't think they should be paying taxes on this plane when it wasn't here. So I would agree with the petitioner that there should be a reduction in the value. And 6 days out of 365 is like 1.64%. The assessed value at $4,157,092 would relate to the 1.6438%, would be about $63,334 $4 or $335. And that would be my motion is that we,
Well, Tim, we're still.
oh, we're discussing, I'm sorry.
Yeah, these are questions or comments for Amy. And then I'll close the hearing and we can deliberate.
That's all I had was just those questions about the purchase price and how many days it was in Nevada. And it's my opinion that they shouldn't be paying taxes on an aircraft that's not in Nevada.
Okay, thank you. Al, any questions?
No,
Amy, the original proposal that was then removed of approximately 122 days allocation to Nevada or apportionment to Nevada, is that representative of the aircraft's behavior during the taxable year in question?
No, it was a portion of the time after the lien date. So if you follow the guidance of the law, the code, I get confused because some are proposed and then some are administrative. It says that if you were going to allocate the plane, you would look to the preceding year. And that's also what the response from the Clark County assessor said as well. So Washoe County attempted to look at the behavior after the lien date for a period of time from July through November, and that value is based upon that portion of time, which is
Well, go ahead.
which is one of the reasons why we did not accept it.
So that proposal was rejected by both you and withdrawn by the county?
No.
It was withdrawn by the county,
Okay,
It was not rejected.
okay.
correct?
Okay. I guess the question that I had, maybe I'll try and restate it. The proposal was to allocate or portion 122 days during the taxable year to Nevada, which represents roughly a third of the aircraft's time during the calendar year. There was evidence presented in the file that supported that for that the math was extrapolated from a 4 to 6 month period to extend for the balance of the year. Is that consistent with the aircraft's actual behavior during the fiscal year or not?
It is not consistent with the behavior for the July 1st lien date. It would be consistent and relied upon for the behavior for the July 1st, 2022 lien date.
Okay.
So according to the statute, if you're going to allocate the value, you look to the preceding year. And so the time period that was looked at would be used for the 2022 filing. And I believe, I don't want to speak on behalf of the county, but I believe the county was looking at it to just to confirm that the plane really was going to have habitual situs, to make sure that was a consistent application, which is what we thought when we provided it.
Okay. Okay. Everybody, I apologize. We're still experiencing somewhat erratic connection, but I think that it broke at a fairly reasonable and convenient time. Lacking any further input from the parties, I'll close the hearing for deliberation. Tim, we sort of heard from you. Al, your thoughts?
Yeah, where the presence of the aircraft was in other jurisdictions, clearly, I think the taxpayer has met the burden of proof on that. And I think there's also potential of double taxation. I mean, the look back period for both California and Nevada is a 12-month prior. There's a 6-month offset, but I think there was some overlap there. But I think the long and short of it is the burden was for the taxpayer to provide evidence that it was in a jurisdiction long enough to acquire taxable situs. And I think they should be allocated for just the 5 nights, 6 days, whichever it was, for the tax year in question.
Okay. Tim, do you have any further comment? Unmute yourself.
Can you hear me now?
Yes.
Yeah, so I already made my statement and my position that the aircraft should only be taxed for the time it was in Nevada. 6 days is 1.6438%. Using the valuation of the $11,877,405.71 with the 1.6%, I think the valuation is I think it was $67,997.26. Let me run that. Did you run those numbers, Bob?
I did not.
Petitioner has a value that's awfully close to that, Tim. I think it's it's in the additional information, very last paragraph on page 4 of 4.
Yeah, they're at $68,335 for the assessed valuation.
Yeah.
Yeah, that'd be my motion. So would we accept the petitioner's assessed valuation for the period of time that was in the state of Nevada?
So you're relying on NAC 361-136, paragraph 2B, that reads the fraction obtained, to read that entire paragraph in there. If an aircraft has taxable situs in this state and in another state or country, the taxable value of the aircraft must be allocated to this state in an amount that fairly reflects the use of aircraft in this state. The portion of the taxable value of the aircraft allocated to the state must be equal to the amount determined by multiplying the taxable value of the aircraft, and B, the fraction obtained by dividing the number of overnights spent by the aircraft in this state by the total number of days immediately total number of days in the immediate preceding fiscal year. So based upon that, we end up with the apportionment of approximately $68,000 for the taxable year 21-22 based upon this formula.
Yeah, $68,334.28, which was rounded to $68,335.
So that's your motion. Do I have a second?
I second.
All in favor, signify by saying aye. Aye.
Aye.
All opposed? Hearing none. Motion carries. Thank you, gentlemen.
Thank you. Absolutely.
Thank you for your time. Christine, is there a way to get a hold of Tyree? I'd like to have his input on this case, next case. What's the next case?
You could call 22-104 and 22-105.
Or you could do minutes.
Or we could do the minutes and a couple of the other items.
That way takes care of some of the other administrative details. Gentlemen, Jeff is going to call some of the other administrative details for our consideration, kind of out of order. Jeff?
Thank you, Mr. Chairman. Jeff Mitchell for the record. Under agenda item F for possible action, review and approval of minutes, June 29th, 2022 and July 20th, 2022 are available for review and recommendation.
Mr. Chairman, this is Al. I make a motion that we accept the minutes as presented for the June 29th, 2022 and the July 20th, 2022 meetings of the board.
Do I have a second?
I'll second it.
Thank you, Tim. All in favor signify by saying aye.
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 Any opposed? Hearing none, motion carries. Jeff, do you want to call 104 and 105?
Sure. So under agenda item E for possible action, we have direct appeals from valuation of the Nevada Tax Commission pursuant to NRS 361.403 for the 2022 and the 2023 secured roll and that is the one under consideration for this case. We have case number 22-104, Albemarle US Incorporated, which is Silver Creek General County. It is mining property. The respondent is the Department of Taxation, and the petitioner is represented by Ashley Moore. Proper notice of hearing can be found on page 27, and it appears that Ashley Moore is available by Zoom. And with that, I will turn it over to you, Chair.
Okay, thank you. This is the opportunity for the assessor to, or the Department of Taxation to introduce the property briefly.
Yes, good morning, Mr. Chairman and members of the board. We have here two appeals from Albemarle.
And state your name, pleplease.
Soren Popa for the record.
Thank you.
And Albemarle Silver Peak and Albemarle General District. And they are located in Landers County.
Thank you. Ashley, it's your opportunity to present your case.
Ashley, can you hear us okay? It shows that you are unmuted, but we can't hear you. If for some reason your microphone's not working, there was also a call-in number that was listed on the notice or the agenda that you can also utilize to dial into, and I can let you speak that way as well. And to answer your question that you just popped up on the screen, yes, you can join as a panelist to turn on your video. It doesn't seem like your microphone is working still. I can read you the phone number that you can call in. So if you want to dial 1-669-900-9128. And then when it prompts you, just go ahead and put in the webinar ID, which is 863-5398-8727. And once I see a new phone number pop up, I will unmute you to speak. Okay, is that you, Ashley?
Yes, ma'am.
Perfect, okay.
Ashley, welcome aboard.
Hi, I apologize for that sincerely. So I did want to address this case, and I apologize, my let me get back to the other screen. So regarding this, to kind of set the stage for this, Albemarle owns a lithium mine in Silver Peak. This facility historically has been the source of most of the lithium extraction for the United States. That being said, this facility has undergone some significant changes, and while we are reviewing all of the assets that the assessor currently has on the roll, we were working with Albemarle to try to understand where some of these assets were located, because it appeared that when Albemarle, which was originally headquartered in Louisiana, was relocated to North Carolina and their accounting records were updated, some assets were erroneously allocated to incorrect physical locations. So what we had provided originally in our preliminary appeal was related to some of the issues that have occurred with spot price with lithium. Because this facility is tied so closely to the lithium market, they are going to be incredibly susceptible to any changes in that spot price. And what we've seen, consequently, is that there are some issues with their ability to generate revenue. But unfortunately, we are still working with our client to understand what the actual assets at this location are. And, you know, I realize it's kind of out of scope of this, but we actually just filed amended returns because while we thought we had the list cleaned up, we discovered there are still assets that we originally filed for this current tax year that are not physically located at this site, that were just miscoded in their financials. So I apologize to the board that I don't have much additional information at this point that I can provide for you. I recognize that, your time is incredibly valuable, but we are working through the process of trying to get the data that Mr. Popa references in his affidavit and confirm and clean it up for the state's review.
Thank you. So to summarize, you believe there are still issues regarding some personal property, but they are not addressed in this appeal. The initial appeal was based upon a drop in lithium prices, which have substantially rebounded. And so that issue has been alleviated. Is that correct?
That's correct.
Okay. Okay, do you have anything further?
Nothing further beyond we did provide evidence post our meeting with the state documenting the assets at that time that we had identified. However, we had also, been sure to assure the state that when we filed for 2022, the subsequent year, the asset list was clean. And unfortunately, we are still working through the process of being able to clean that for them. So the taxpayer, wants to be sure to, acknowledge and apologize to the state that we haven't been able to give them everything they need to support, and also obviously apologize to the board that we don't have everything we need to provide you at this time.
Okay, so the only issue that was addressed in this appeal was the valuation concerns regarding lithium prices. And so that's really the only issue that we can hear at this point. Next year, if there's issues regarding personal property or the valuation of the resources, we can address that. Board, any questions or comments? None? You may have the floor.
Thank you, Mr. Chairman. First of all, I would like to make a correction. It's the County of Esmeralda, not
Okay.
Flanders. And given the facts that there are no further issues, the price of lithium, as it shows on SBE 25, skyrocketed in the past couple of years. So I strongly believe that the values that were determined should remain unchanged.
Thank you. Board, any questions or comments?
I do. As a mining property, is this not taxed through Nevada net proceeds tax?
The net proceeds applies to the actual mineral being extracted. This is for real or personal property.
Okay, so it's in addition to that. My curiosity was if the net proceeds tax doesn't by definition reflect the change in the market, the spot price of lithium.
Oh, yes, it does.
Okay.
But if there's some resulting impact on the underlying real or personal property values, that would be reflected in this.
Right.
Okay. Al, any further questions or comments?
No, thank you.
Tim? Tim, any other questions or comments?
No, not now. Thank you.
Okay. Ashley, you have an opportunity for a closing statement.
We have nothing further.
Okay.
And we
thank
appreciate
you.
your time.
Thank you. I'll close the hearing. Any discussion or deliberation or a motion? Al? Tim? Well, Al, if you're doing something, you're muted.
I'll take a crack at a motion.
Thank you.
Did we call both cases?
Given the evidence and testimony provided today, just in that the taxpayer was still gathering information that would be provided this board. Absent that, I would motion that we accept the assessor's taxable value in this case 22-104 and 22-105.
Actually, Al, I think we just called 104.
Okay,
So
I'll prune it back down to 22-104.
thank you. Do I have a second?
I'll second that.
All in favor signify by saying aye.
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 All opposed? Hearing none, motion carries. Jeff, if you would call the next case.
Thank you, Mr. Chairman. Under agenda item E, we have case number 22-105, Albemarle USA, the Silver Peak District, mining property located within Esmeralda County. The petitioner is represented by Ms. Ashley Moore, and the respondent is the Department of Taxation. Proper notice of hearing can be found on page 36 of that packet.
Okay, Department of Taxation, introduce us to the property.
Yes, sorry, Popa, for the record, we're dealing with a property next to the one in the previous case, still Albemarle Silver Peak, in the county of Esmeralda.
Thank you. Ashley, this is your opportunity in case 22-105 to present your case.
Good afternoon. Again, we are in a similar situation to the prior case. These are two accounts for the same functional property. They just deal with different, slightly different districts and slightly different components of the same facility. That being said, we understand that the evidence provided in the original petition no longer reflects the taxpayers' concerns. So, we understand that the board is not going to be able to rule on anything beyond what has been provided, and the lithium price has been alleviated. So, we'll just leave it at that.
Okay. Thank you.
No further comments?
Ashley, any closing comments?
No, sir.
At this point, I'll close the hearing for deliberation and a possible motion. Tim, any questions or thoughts? You're muted.
I'll let Al go ahead.
Okay.
Okay, so somewhat resting on the testimony of the previous case and the rationale for the motion in 22-104, I also motion, given the lack of evidence presented by the taxpayer, I motion that in case 22-105, we accept the assessor's valuation for the tax year stated.
I'll second the motion.
All in favor signify by saying aye.
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 Any opposed? Hearing none, motion carries. Jeff, do you want to, I think we'll take a 10-minute break and then we'll talk about the Ruby pipeline. That works for everybody. Meeting adjourned for 10 minutes. As long as you stick with us, we'll be okay.
Yep, got you.
Okay. I'm reconvening the October 11th, 2022 meeting of the State Board of Equalization. Jeff, if you would call the next case.
Thank you, Mr. Chairman. Jeff Mitchell for the record. Under agenda item E for possible action, direct appeals from valuation of the Nevada Tax Commission pursuant to NRS 361.403. We have case number 22-102. Petitioner is Ruby Pipeline, represented by Mr. David Crapo and Mr. Brandon Greer. It is industrial property valued unitarily or centrally assessed, and the respondent is the Department of Taxation. Proper notice of hearing can be found on page 1222. With that, Mr. Chairman, I will turn it over to you.
Thank you. Department of Taxation, if you would briefly introduce the property.
Yes, so for case 22-102, we have Ruby Pipeline, which is a company that goes through 4 states, Wyoming, Utah, Nevada, and Oregon, and therefore it is centrally assessed.
And it's a natural gas pipeline.
Yes.
And related facilities.
Yeah.
Okay, Mr. Crapro, I'm not sure which of you is going to kind of lead the charge, but it's your opportunity to present your case.
Thank you.
Please introduce yourself. And
Yes. My name is David Crapo, and I'll act as representative for Ruby Pipeline today. With me is Mr. Brandon Greer. He's the tax director at Ruby Pipeline. And then also on the call, we have Mr. Nathan Hersher, who's an MIA appraiser who did an appraisal of this property, and he's available to answer questions as may be needed. So let me just call the board's attention to what we have here. We have an assessment from the department that we disagree with. Their unitary assessment, meaning the entire system of the pipeline in the 4 states, they assessed at $1.9 billion. We believe that assessment should be about $544 million for the system value. There are really only 2 issues that make up the big difference. One is, do you recognize obsolescence for an impairment and write down in the assets that has occurred in the cost approach? If so, the cost approach drops dramatically. The second issue is, do you recognize that the firm reservation shipper pay contracts that were initially signed, do you recognize that those are all going to expire and in fact have not been renewed during this year? And you recognize that that revenue is not going to come into your income approach. If you do, that drops the income approach down into the 500 million range. So those are the 2 issues that we disagree on. So I wanted to give just a little bit of summary about this pipeline and the issues. In the exhibits, and thank you for putting those together, Christina, on SBE 109 is our Exhibit 1, which is the system map, if you want to look at that on your PDF page. This pipeline runs from the resource fields where there's drilling in the Opal area of Wyoming, runs through Wyoming, the northern part of Utah, the northern part of Nevada, and then goes into Oregon and goes right along the border of Oregon. The original hope of this pipeline was that you could move resource from Wyoming over to the Pacific Northwest and then eventually do a connector from Malin, Oregon, up to a facility. It was going to be a liquid natural gas facility further into Oregon called the Jordan Cove. Now, for pipelines, as you may be aware, typically an owner of a pipeline won't build a pipeline unless they've got guarantees from the shippers that they're all in, because it's expensive to build a pipeline. This is true here too. And so the shippers came and said, we'd like to do this. And they said, fine, if you'll sign really a construction loan guarantee, which is in the form of a ship or pay, which means you're going to ship product over this pipeline if we build it for you. And if you don't, you'll pay us anyway. So it's you ship and you get paid, or if you don't ship, you get paid. And those were 10-year contracts, primarily to run from the initial signing or the initial opening of the pipeline, 2011, until 2021. Unfortunately, what happened with this particular pipeline, prices changed dramatically, and then also markets changed dramatically. What happened primarily is there were major discoveries in other parts of the country for resource. The Permian Basin, which you've heard about in Texas, the Canadian bases right up along the border, and then the Bakken in North Dakota. And as a result of those, producers moved out of Wyoming and no longer wanted to produce there because they could produce in other areas cheaper and they could get it to market cheaper, which left this pipeline in a vulnerable spot. because a pipeline only makes money on shipping. It doesn't own the natural gas. It doesn't own the product. It just gets paid a shipping fee. There are two primary owners of the pipeline now. Kinder Morgan is one, and Pembina, which is a Canadian-based company, is the other. Pembina hoped to connect to Jordan Cove and be able to reestablish some desire for this pipeline. That unfortunately did not happen. So I'd like to direct your attention to our Exhibit 11, which is on SBE 740. And I'll do that in live time with all of you, so we're on the same page. 740 is our Exhibit 11. And the first page of SBE 740 is a pie chart. If you go to the next page, you'll see the data for the pie chart. This is also in the appraisal by Mr. Herscher and Mr. Cook. You'll see that to get this pipeline going, they were able to get all of these companies, the 13 identified there, to enter into shipper pay contracts. What is interesting is every one of those shipper pay contracts has a clause in it to say, if you want to renew, you have to give us a year notice. So by June of 2020, you'd have to give notice. Now, the assessment or valuation date in this case is December 31st, 2020, or January 1, 2021. So as of June of 2020, the contracts that came up, none of them renewed, not one. And the only ones that were left, if you look at the pie chart, would be Pacific Gas and Electric and Cascade are the only two that still have time remaining on their contracts. So you'll see that about 75% more or less of the revenues for firm payment were going to disappear because those were not renewed, and that was known in June of 2020. Now I'd like to go to the next exhibit that we have on SBE 743. This is just to show you a little bit of the magnitude, and this is a chart. The support data is on the following page. You'll see in blue, the majority of the revenue coming to this pipeline were shippers paying their firm contract, which was to say, we're not shipping, there's no need to ship, there's no market for it, but we owe you. And so what's going to happen in 2020 when they didn't renew? Those are going to drop off, and then the rest will drop off later in the future. And so you can see the dramatic drop off in the revenue that's occurring for this particular pipeline. So knowing that these would not renew, what did the company do? And I'd like to direct to Exhibit 2, which is the annual return. And I'd like to direct your attention to SBE 127. In the annual return, the taxpayers required to report what were the last 5 years of revenue and what do they think is going to happen for the next 5 years of revenue? Because an income approach is. Pardon?
Hold on just a moment. Because of the magnitude of the case, I'd like the full board to be present. It looks like Tyree's back.
Okay. Thank you. I'll go ahead and continue.
Yeah, I apologize for the.
I'm on the annual return that's submitted by the taxpayer to the Department of Revenue, which is our Exhibit 2, but I'm looking at page SBE 127 of that document.
Is that something filed with Nevada or with the?
With Nevada.
Okay.
So each year the taxpayer is asked to fill out a form that's about 20 or 30 pages and give it to the Nevada Department of Revenue to sort of summarize what's happening with the property. And on Schedule 11, which is this SBE 127, this is where the taxpayer can show what's happened for the last 5 years for revenue and what's expected for the next 5 years. And you'll see in the last year in 2020, they had about 139 million. There was 10 million more when you look for other income, so 149. But then you'll see in 2021, they expect to drop to 86 million. And 2022, they expect to go negative in that particular year. So the taxpayer is very concerned. They knew there was this big drop off, so they also went and retained two MAI appraisers, Phil Cook and Nate Herscher. and they prepared exhibit number 10, which starts on SBE 673. And 673, did I get the right one? Starts on 670, it's exhibit 10, 670 is the slip page, 671 is where the appraisal starts. And those are two licensed MAI appraisers in Utah, and they have temporary licenses with the state of Nevada. They prepared this appraisal, and the client took it and they gave it to the Department of Revenue even prior to the assessment time, saying, we've got big problems. We want you to know what these issues are. And this appraisal was given to them. And the two issues that I just mentioned are called out in this appraisal. And let me go to exhibit 14. And we have a summary slide at SBE 752, I believe. Yes. So if you look at exhibit SBE 752, we've just put in an Excel spreadsheet the two valuations that are issued. And you'll see on the left in orange is the Department of Revenue. They did a cost approach at 2.7 billion, an income approach at 1.4 billion plus. The correlation weighting comes out to about 36.64. They did not identify that in their correlation or in their assessment. But if you just have two, you can, and you know what the final number is, you can back into it. You'll see that in the appraisal for Mr. Cook and Mr. Herscher, their estimates are in the 540 range for both the income and cost approach with a 30/70 weighting. And then you can see in the red box the difference that I mentioned at the very first that's associated with this case. We are not disputing the allocation to Nevada of 47+%. We're not disputing the calculation of the market to book ratio for other adjustment properties. So the only thing really at issue are the two approaches. Now, if you'll look at the next a few more pages down to SBE 754, you'll see a summary of the cost approaches, the one issued by the department on the left in orange and the one on the right issued by the appraisers. You'll see the only main difference is an obsolescence adjustment of $2.2 billion on the right column highlighted in a red box. So the question becomes, is that adjustment appropriate? Now, under Nevada's administrative code, it says that the cost approach is you take the gross cost, less depreciation of all forms, physical, functional, and economic, and that includes economic obsolescence, and you remove that to get to your cost indicator based on the financials. So does this $2.2 billion show up anywhere, and was it on the financials? It is on the financial records. This pipeline, because it's owned by two publicly traded companies, one in Canada, Pembina, and Kinder Morgan, United States, they're required to have audited financials every single year. Exhibit 4, beginning on SBE 317, are the audited financials.
You have 5 minutes left.
I will try.
Jeff informed me that on a direct appeal, the timelines are much more flexible.
Okay, no worries.
Thanks.
Thank you. I'll try to be as
No,
efficient as
it's
possible.
a complex issue, and we're more than happy to give you the time that the issues deserve.
Thank you.
But I do appreciate your brevity.
I'm
That's it.
I'm going to try to be as brief as possible. So if you will look at SBE, and SBE 321. If you look at the first of this is the audited financials from PricewaterhouseCoopers for the pipeline. This is the statement of operations, and you'll see about 6 lines down in the 2020 area, it says long-lived assets impairment, note 3, 2.2 billion. So they're making an adjustment for 2.2 billion. Now, companies don't like to impair their assets because they're basically saying we can't get our money from it, and investors get really skittish with that. And so they don't do this lightly. So if you'll go a few more pages into this document to look at note 3, and that is on SBE 329. And if you look at note 3, it says long-lived asset impairment. And you'll see the paragraph under that says, as of December 31st, 2020, we evaluated the recoverability of the carrying value of our long-lived assets. The evaluation was triggered by what? Says the uncertainty for the contracts that we talked about, and then significantly increased uncertainty about the development of the liquefied natural gas facility, Jordan Cove, and then other demands in the area. And then it goes on in the rest of this note and says we did an undiscounted cash flow as required by accounting rules for FASB. And we also did a discounted one and compared those. And they said, we've come up that our assets are impaired by 2.2 billion, and that's identified in that note. And so the books show that there's economic obsolescence that's been known, and it's measured, and it's been experienced. Now, if you look at the next exhibit, which is the 10K for Kinder Morgan, and Kinder Morgan is publicly traded, and I direct your attention to page SB 430. In the middle of this page, third paragraph from the bottom, Kinder Morgan is recognizing this same impairment, and it's reporting it to its shareholders. Our largest impairment for the year, December 31st, 2019, is $650 million non-cash impairment in our investment in Ruby in our natural gas pipeline segment. And then you'll see they say why. Increased Canadian gas supplies, because the market's better to get it cheaper to market there. Competitions from others, upcoming contract expirations, and then you'll see the rest. Now you ask the 650, why is that? Kinder owns part of the pipeline and Pembina owns the other part. So the 2.2 billion has to be allocated each one. Plus this is an investment in equity, so you'll see a slight difference. But if you look at the Pembina public report, which is their annual report filed in Canada, which then also gets submitted to the United States, and that's our Exhibit 6. And I'm going to look at SBE 544. And if you look on that page in the middle, there's a heading that says Ruby. And this is the Pembina annual return. And it says in December 2020, Pembina recognized an impairment of its full convertible preferred interest at 1.3 billion and related parties, and then the 1.4 billion. And then it says why? Because of triggered by upcoming contract expirations with existing tariff rates, declining Rockies Basin's fundamentals, and the uncertainty with Jordan Cove. You'll also see Jordan Cove. Pembina was the developer of it. It's right above it on this page. And Jordan Cove was fully impaired as well because they couldn't get permitting to build it and the facility was scrapped. So there was no hope of ever doing that one as well. So you've got financial records that are publicly available in the United States federal government, the Canadian federal government, and the audited financials all showing this impairment. And so we believe the cost approach has to be impaired by the 2.2 billion as Mr. Cook and Mr. Herscher did in their assessment, and that the department did not. The next one is the income approach. The income approach is a yield cap approach, which is where you take a set of income and then you capitalize it by a cap rate. Let me direct your attention to that. SBE 756 is our spreadsheet. And what the department did is they followed some of their rules and said, well, we have to look at just the most recent year, or we have to look at the last 3 years. So they looked at the last 3 years and averaged and came to 162 million, and they capitalized it at 11.37. We don't disagree with the cap rate. Candidly, the appraisers came to about a 10, which is lower, which a lower cap rate means a higher value, all things being equal. I mean, we don't dispute the department's cap rate. What we do dispute is the average income. Mr. Cook and Mr. Herscher, rather than use a 3-year average or even use the last year's number of 150, they said, we know what's going to happen. The contracts have already been canceled. And they looked at an internal forecast the company had put, which is on SBE 661. And I'll direct your attention there. 661. And this is where the company did their own forecasts, and they showed, we know the contracts are expiring. We expect to drop operating income down into the 80 million range in 2021. So Mr. Cook and Mr. Herscher knew that an income approach is anticipatory in nature, and you try to figure out what your income is going to be. And so they did a DCF model. They did a 5-year model with a terminal value. You could shrink it to one step, but they used that and they came up with the 544. Is it appropriate to take out, if you will, the revenues? And we believe it is. We talked about that in our reply brief, and I'd encourage you to review that. But in the code, Nevada Code 361-408, it says when you're looking at income to capitalize, they say with regard to industry groups with annual earnings that are reasonably stable, it says the most recent year earnings may be used. Because they're saying, okay, if you're reasonably stable and you're going to be pretty constant, maybe that last year is a pretty good indicator of what's going to happen. So you may use that. Well, we're not reasonably stable. The second one is if you're in a group that vacillates frequently over a period of years, you can look at a 3-year average and it says, and that may be used if it's indicative of what's going to happen. It's permissive. It says may. And under Nevada law, under the visual communications case from your court, it says any interpretation of the statutes are to be interpreted in favor of the taxpayer. Any ambiguity is interpreted in favor of the taxpayer. So we believe that Mr. Herscher and Mr. Cook did the proper analysis. And our burden for you today on your board is that we're supposed to prove by appropriate appraisal standards that are generally accepted that our value is correct. And Mr. Herscher's available, but the model he used is the generally accepted model, and we'd ask you to adopt that. So with those two in line, we think the 544 is a reasonable assessment. And we're open for any questions and be happy to respond to any comments.
Thank you. Board, any questions? Al, I was particularly interested in your input because of your resource background.
Yeah, the pipeline is something new to me, but a couple of things that I held my hat on is just the financial aspect of it. Taxpayers correct. Public traded companies will not lightly do these asset impairments. It's like the last thing on earth they want to do. So that's a compelling piece of this. I don't know. Is this an asset that would be sellable? If you were to sell this asset today, what would the just as a benchmark, what do you think the marketable value of this asset would be?
That's the $10 million question today.
Or $2.2 billion question.
I can respond, and then if Brandon would like to add, he can. I don't want to get into post-lien date information, but I know you have some in your briefing. The pipeline filed for bankruptcy in March of 2022. And Mr. Popa noted in his brief, under the bankruptcy, they're going to open an auction this month, next month in December, and review bids to buy the pipeline. And so it is going to go up for bid. Now, this is all post-lien date information, but the question is, will we get 300 million? Will we get 400 million? Will we get 550, 544? We don't know. It's been impaired, and I'd be speculating to know what the bids are because they're closed bids going in. Is there anything that needs to add to that?
No, I mean, once we get through the bidding process, we'll know what.
Hey, this is the court reporter. Could you please identify yourself when you speak?
I'm sorry, this is Brandon Greer with Kinder Morgan.
Thank you.
So once the bidding process gets through, towards the end of the year, then we'll know if it's gonna be sold up for auction or not. And the bankruptcy court will determine that.
Does the current customer base have any impact on what the future looks like? If the ultimate end user, do they have a defensible position in this, the outcome of this pipeline?
Well, maybe I understand the question. The pipeline runs from Wyoming to Oregon. You have Kinder Morgan and Pembina who are partners. They can post up their debt, I guess, to be as a bid maybe. Right now, there's PG&E who has a contract, and Cascade. PG&E, as you're aware, filed bankruptcy a few years ago. Luckily, they've still been making their payments, but their credit rating is dropped below what is acceptable for firm and ship contracts. So you have to say, what would a would-be buyer look at? I think they're going to come in and say, I have no guaranteed contracts. The one I have is with an entity that is subpar credit rating. And any of the other projects on the end have not been allowed to be permitted. What's my likelihood of making something out of this pipeline, especially when you're competing now against Canadian source, Permian Basin source that's cheaper to produce, and the producers have moved there. And unfortunately, our pipeline's stuck in an undesirable spot.
So my interpretation is that, and correct me if I'm wrong, I'm looking at the financial projection on page 661. We are anticipating that the volume of product transported will remain relatively stable. The take or pay contract reserved additional capacity. At this point, there's not the risk that PG&E or whoever controls the transportation demand or supply will run up against capacity caps within the pipeline. But so the take or pay contracts are not necessary, but they will continue to ship product that's available.
Right.
Your financial projection shows the same number under usage, same dollar number under usage.
Right. Remember the blue chart I showed you that fell off?
Right.
The people with firm contracts, if they can ship some, they will. They ship some, but then not all, so they paid the rest. Their best estimate, as you can see, is that it's going to fall down into that 80 plus of revenue, 80 million of revenue. Contracts will expire, then they'll try to get people to sign up. Maybe some of those people will sign up for a 1 or 2 or 3 month contract for a spot and try to ship. But the pipeline has always been, I believe in the appraisal from Mr. Herscher, operating, 40%?
40 to 50.
Yeah. And there's no expectation it's going to get any better than that I'm aware of.
Not that we've been told.
Is there a price? Is there a resource price that would prompt Wyoming's development to resume? Or are they just out until Texas runs out of gas?
Brandon Greer, we're not a producer. I can't speculate to that. We don't know what prices would draw producers back to Wyoming. We're just the pipeline company.
But you invested $3 billion in a pipeline based upon some sort of projections initially, and it worked for a while until it stopped working. Okay.
To respond to your question, though, you've looked at spot prices that have been discussed.
Right.
I think at the time this was contemplated in 2007, spot prices were 7 to 8%, 8 per MCF dollars. It will really be speculation, because what's going to happen is you've got to get producers back into Wyoming to drill and want to move. Right now, all of those entities have moved to the basins I've mentioned, and they can drill there cheaper and they can ship cheaper from those. So you've got to add two things in. Will they go back because the price is high enough? And is the cost to ship from Opal to Oregon that you add on to that price incrementally going to make this go? Thus far, the company looking 5 years the best they can into the mirror, into the future, they're saying, no, it's not going to happen.
Did you mention,
Go ahead,
sorry,
Al.
did you mention earlier that, and this is probably out of your realm, but did you mention earlier that there was a producer that was unable to obtain permits?
That was related to Jordan Cove. Jordan Cove was going to be a liquefied natural gas facility on the Oregon coast, and they were going to connect this pipeline with a connector pipeline to that, and then they're going to liquefy the natural gas and then ship it, export it throughout the world. FERC initially approved that project, but then the state and the tribal areas spoke up and it got withdrawn and was not approved, and they took away any permitting. Pembina tried to do it again and finally just gave up. They said it's never going to happen. We can't make it economical, and it's off the table at this point.
The other question I had was the impairment that is presented in the financial statements. Were those based upon the appraisal, or was that impairment based upon an internal calculation by Ruby?
Internal calculation by Ruby.
And that, I'm looking at 661, that's the income projection that Ruby used when calculating the impairment.
I don't know. I haven't seen the impairment. I don't know if they use these numbers exactly. Do you know?
I don't know. I haven't seen the specific impairment study.
Okay.
We've just been relayed this document from our accounting.
Okay.
So I would have to assume that they use that or something very similar to it.
Okay. Board, Tyree, do you have any thoughts or comments at this stage?
None for me at the moment, Mr. Chair. I will just add a comment that, I am persuaded by the impairment on the financial statement as well. Again, my background being in minerals, there are times where we will halt operations, go into care and maintenance, waiting for the price to adjust. I am going to make an educated assumption that, that happens equally within the oil and gas space. And so I think, where there are contracts that may not have been renegotiated, my question, I guess, for the presenters are, do you see these contracts being maintained even though at the moment they have not been renegotiated? So do you see a company saying, hey, just in case we go back in, let's keep this contract alive in some way, shape, or form, but there's not an interest to enter into a long-term contract?
I can comment and then fill in. The original take-or-pay contracts were 10 years in term. That's a long term, and the pipelines require that because they want to make sure they're going to get some of their construction costs back if they're going to build this pipeline. At least at the time of renewal of June of 2020, none of these shippers wanted to bite off that. They wanted these contracts to go away because they didn't want to be obligated. And typically what that means is, hey, if we've got something to ship, we'll go renegotiate a couple-month contract at a much more favorable price where we don't have to be on the hook more than a couple of months. But Brandon, you probably know that better than I do.
Yeah, I think if they are entering back into new contracts, they're at much reduced rates and much reduced volumes. That's what was indicated to me.
And what would the terms be? Would it be very long?
No, they'd be 3 to 6 months at most.
So as of today, have any of those contracts been, to your knowledge, I guess, have any of those contracts been entered into? Because you're telling me that it was a 10-year contract. They had a 1-year opportunity to state their intent, that would have been in June of 2020. So then that means in June of 2021, have all those contracts now, are they all gone, or are they renegotiating but just at a lower rate?
This is Brandon Greer. Technically, those contracts are gone. Some of those shippers, I don't know exactly which ones, may have entered a new contract at a much shorter time window, a much shorter or much reduced volumes, and much reduced pricing.
And shorter duration.
Yes.
So we've got this volume to blow through the pipeline right now.
Yeah. And there is capacity available on the line to, if somebody calls up and says, hey, we want to ship some gas, that they can enter into a short-term contract. Because these take or pays have expired, there's no guarantee on volumes being contracted.
Okay, thank you, Mr. Chair.
Thanks, Tyree. Is there and I'm going to use the wrong terminology, and I understand because I don't know your business, but is there a difference in price on a transportation cost between the spot price, the short-term contracts, and the take or pay? It looks like the take or pay was really not a transportation contract, but a guarantee of capacity. If there's no guarantee of capacity, does the revenue from the volume of transported material increase to kind of compensate for that lack of, in the original scenario, the producer has a cost to transport a certain amount of product that includes both the take or pay contract and the spot transportation cost. Because we've got the two lines, we've got the usage and the reservation separate. When there's no reservation, is that revenue just lost and the cost of transportation remains unchanged on the spot basis? I'm not sure I explained it.
I can take a crack at it. This is a natural gas pipeline, so it's rate-based regulated. And so their rates are calculated and set for shipping of MCF, and they're obligated to they're an open market shipper. So if somebody comes and you've got space on your pipeline, you have to say, I'll ship at this rate. And so that rate has to stay pretty constant for shipping from, you can have different places you put on your gas, but from Wyoming to Oregon, and I don't know what the cost is, but let's say it's $2 an MCF, for example.
Whatever it is.
Just say, hypothetically, it's $2. If I come and say I've got X quantity of decatherms, they'll say, okay, we'll enter into an agreement, it's $2. But if you'll agree for a couple of months, we can reduce the price to 1.8 or something like that.
But that regulated price does not include the reservation cost. That's above and beyond in order to facilitate the existence of the pipeline and available capacity. The transportation rate remains unchanged whether you've got the reservation or not.
That's my understanding. So if you were to take one of these, add 325 decatherms they're supposed to ship. That was their reservation, their shipper pay. And they only ship, say, 100. They have to pay as if they ship 325, even though they only shipped 100 at my hypothetical, the $2. When this contract goes away, that customer is going to say, I don't want to be on the hook for $225,000 anymore shipping. I'm going to go to the company and say, I think I can reasonably ship 80 to 100. Can I enter into a 2-month contract with you to ship at $2 for that 100? So everything that's above that reservation piece, it's evaporated, it's gone. The market doesn't want to take that spot. And so that's what they're saying is the big drop off.
So the reservation price is really the transportation cost based upon full capacity or the full fulfillment of the reservation.
Correct.
Right.
So if the shippers entered into a reservation contract firm transportation contract. Basically, whatever they ship up to that maximum daily quantity is what they pay, whatever that negotiated contract rate is. So that usage piece that you see on the financials, that's anything that if a shipper, another third-party shipper came in and said, hey, we on a short-term basis, we want to ship some gas. That's what that usage piece is. It's something. It's gas that's being moved on the pipeline that's outside of a firm transportation agreement.
Okay.
Yeah.
Tim, Al, any further questions, comments at this stage? Hearing none. Department of Taxation.
Okay, thank you. So I will start
I
by,
think, hey, sorry, I see Tim's
Tim,
muted, but he's waving to make comment, I think.
Still muted.
Tim, you're still muted.
Can you hear me now?
Hear ya.
Okay. I understand that the one of the appraisers is on the line with us. Is that correct?
Yes, Mr. Nate Hersher.
Has he been sworn in yet?
I believe he was on the call when they did the swearing in the morning. If he hasn't, he could be sworn in again.
Can we get make sure he's sworn in?
Sorry, this is Nate Hersher.
Okay.
Have you been sworn in, Nate?
Yes.
Okay. I was wondering if you could look at SBE 32.
Sorry, give me that number again, Mr. Morse.
SBE 32. That's your certification?
Yes, sir.
It says number 14 that Mr. Cook is a certified general appraiser of the state of Utah. And then number 15 says that you are. And then what is the date of the appraisal report?
The date of the appraisal report, oh, sorry, I skipped ahead. The date of the appraisal report is April 23rd, 2021.
So that's when you wrote the report and used all of that data that's contained in the report to come to that conclusion. It was as of April 23rd, 2021.
Correct.
Your attorney stated that you have a temporary permit in the state of Nevada.
Correct.
When did you get that temporary permit?
I obtained that temporary permit in preparation of potentially testifying today. So I believe it's dated October 3rd of 2022.
Did you have a temporary permit as of April 23rd, 2021?
I did not.
Did Mr. Cook have a temporary permit when he appraised property in Nevada on April 23rd, 2021?
I don't know that for sure. I know that he's had a license in Nevada historically in the past over the years. As of that time, I don't know whether he was licensed or not.
Well, I took the liberty to check with the Nevada Real Estate Division about both of you gentlemen to see if you had temporary permits when you completed this appraisal on April 23rd of 2021. And they tell me, no, you did not. Okay. You did not, and neither did your associate have a temporary permit. So you may have violated Nevada law in doing this appraisal on April 23rd, 2021. You were not properly licensed according to the information from the real estate division. And I see that Mr. Cook on his qualifications on SBE 94 is a prior member of the Utah Appraisal Commission and teaches USPAP courses. Is that correct?
Historically, yes. He doesn't currently, but historically.
So he would have been well aware of what the regulations were in Nevada as of the date of when he wrote that appraisal, that he should have had a temporary permit. Is that correct?
Well, generally speaking, with unitary property such as this, where it crosses multiple state lines, we in the past, and I've seen with other appraisers in other cases, have only been required to be licensed in one of the states which the property is located. If Nevada is specific, my sincerest apologies for potentially any sort of violations. However, like I stated, we did obtain temporary licenses in preparation of this hearing.
Yes, I noticed that you did not get that permit until last week. Is that correct?
Yeah, that's correct. Like I said, that I think the date it was approved was October 3rd.
Yeah, October the 3rd is when the real estate division confirmed that you both received temporary permits. So was your associate planning on testifying today as well? Is that why he got a temporary permit in last week?
He got a temporary permit last week, essentially because I did, but unfortunately he had a conflict today, so I was the only one planning on testifying.
Okay, well, I'm of the opinion that the appraisal report should be disregarded, as it is not prepared by legally licensed appraisers as of the date of the report. Michelle, didn't we go through this last time with unlicensed appraisers, or is there something that you would like to state?
Yeah, well, you have a regulation on this, as I've told you guys, you know, you do. You can give it the way you want to give it.
What is the potential ramifications to Mr. Herscher here in the state of Nevada for testifying today on an unlicensed appraisal?
Well, that would be up to the appraisal commission and the real estate division, and it's not under the jurisdiction of this board.
Is there a potential, a possible fine that would be administered by the real estate division? Are you aware of what that would be? Ms. Briggs? Are you there? Hello?
Did she freeze?
She's frozen.
Bob, can you help me out here?
She's coming back. Michelle, if you would unmute yourself.
Sorry, yeah, that disconnected. So that would be under the jurisdiction of the real estate division and the appraisal commission, and not this board.
So any ramifications would be based upon a referral. Is that
If you wanted to make one, yes.
okay?
Okay, I guess we'll consider that, Bob. Mr. Herscher, on your appraisal report, SBE 44 is that has all the historical operating revenues. And then on SBE 47 is the forecast of their operating revenue. Are you with me on that, sir?
Yes, I follow you.
SBE 47. And it says that the revenue forecast is provided by the operator. So that's your client, Kinder Morgan, prepared these revenue forecasts?
Yes, Ruby Pipeline, but their parent is Kinder Morgan, correct?
And you adopted those and used those numbers?
I have.
Is there any other source of information that you could share with us that you considered that would verify and approve those numbers to be reasonable and persuasive?
Absolutely. So as was discussed, I looked at the actual contracts. I looked at those expirations. I looked at this revenue was not expected to continue moving forward. So a figure below historical revenues to me was well supported. In addition, those, as Mr. Greer stated, there are some short-term contracts that were entered into towards the end of 2020. Again, those were short-term under less than a year at significantly lower rates than what the other historical contracts were entered into. That, in addition to information provided in the annual energy outlook provided by the Department of Energy, as well as other information from the Department of Energy in Wyoming, supported all of those forecasts that revenue would be declining in the near term, and it was not expected to continue or to increase over the long term.
So you're relying upon information you got from the state of Wyoming, and that was in that publication that you referred to just now?
Correct. I believe it's on page SBE 46.
And do that oil and natural gas resources in Wyoming, do they make projections on revenues, or do they just state historicals?
No, they made projections. In that last sentence of that first paragraph, it said many new oil or gas wells are unlikely to be drilled at current prices.
So that's not a projection of revenue. That's just stating that things are unlikely to be drilled. They have given no weight as to how the dollar amounts or anything like that, or what the impact is going to be. And you
the number of wells would have to increase in order for revenue to increase, because the gas would need to be produced in order for it to be transported. And if the gas isn't going to be produced, it's not going to be transported. Hence, revenues are not, in my opinion, I interpret that as revenues aren't expected to increase in the future.
But they made no comments about dollar amounts or declines. And you have just adopted the company's position on the reservation, where you told me that you looked at the actual leases. But then on the usage line, you have utilized that same number every year in your forecast in 21, 22, 23, and 24. You didn't change the usage number, but you changed the reservation number.
Correct, because that's in line with the contracts that I reviewed.
As far as the reservations?
The reservation and usage. All new contracts weren't for reservation, they were for usage. And so, and again, they were short-term on basis. And so, they supported these forecasts provided by the operator.
Okay. So that's what you basically did on your DCF on SBE 71, was take the revenue that the company gave you and utilize that for your total revenue. And you pretty much did the same thing for the expenses. You utilized the company's forecast. Is that right?
Correct. I utilized company's forecasts, which were supported by market data.
Supported by what?
Market data.
The expenses were?
Yes, they were supported by historical operating data.
From the company?
The company's historical operating data, correct.
So you didn't have any other companies to look at? You didn't have any other comparable expenses to look at?
As a percentage of operating expenses, it was similar to other pipeline companies that I've appraised.
Okay, do you have that in your report?
I do not believe that's in my report, but it was something that was considered in completing my report. It's in my work file.
Okay. So on your cost approach on SBE 76, you use the asset impairment, the obsolescence of the 2.2 billion. That's exactly what you used with the company again provided you.
Correct. All of the information presented there is company provided from their audited financial statements, which is typical for a historic cost less depreciation method.
I'm sorry, it's what?
That's a typical methodology for the historic cost less depreciation method, is to rely upon audited financial statements from the entity being and the asset being appraised.
Yeah, I agree with you, and I agree with Al, the point that he made earlier that these audit financial statements are supplied by very reputable accounting firms and are given to the SEC, and so the public can rely on them, and that they're reasonable and can be realistic. Is that correct?
Correct. Yeah,
Okay.
these are audited, I believe, by PricewaterhouseCoopers, and so they are considered reliable by the public.
Yeah, Mr. Chairman, that's all I have. I was number one concerned about the license status, and I found out that they were not properly permitted at the time they did the report. And there is other information in the file and in the from the SEC documents that there really is some obsolescence to this property that should be considered. Thank you.
Thank you. Nathan, I'll ask you the same question I asked Mr. Prepro. In the information that you've reviewed, does it appear that there's a price at which Wyoming exploration would become viable and would reactivate, or is that just an issue that's not been addressed given the plethora of supply elsewhere?
It really is a plethora of supply elsewhere. While price is a factor, the resource, the amount of resource, and the ease of extraction and transportation are just so much more beneficial in the other basins, such as the Permian and the Bakken, that there's very limited activity occurring in Wyoming.
Okay, thank you. Gentlemen, do you have anything to close with? We're going to go over to the Department of Taxation for their presentation. You'll have an opportunity to close, have a final statement, as will they.
Thank you. I did have one comment while we're here on the licensing that maybe it'd be appropriate to address now than later. I just wanted to make sure I addressed any concern that board member Mr. Morris had. And I just want to make sure it's clear what's going on here. The pipeline passes through 4 states, and these appraisers are licensed in the state of Utah, which is one of those states. They prepared a unitary value, which is the value for the entire operating unit. They did not do an allocation to the state of Nevada, and they did not come up with an assessed value for the state of Nevada because we did not challenge the allocation at the 47%.
So the $550 million rounded number is the system-wide valuation.
That is correct. And that's the number they came up with. They never did a Nevada allocated. We used the 47% that the department used. We didn't challenge it, applied that to the 54 and came up with the 90 million that is the Nevada allocated assessment. So I wanted to be clear. It's very typical for unitary properties that are pipelines across the country or railroads, et cetera, that you're not required as the appraiser to get a license in all 32 states, if it is a railroad, or 4 or 5 states to do the unit value. Perhaps if you're going to do the value coming down to the particular state, perhaps. We, on our brief, and I would direct you to our reply brief, SBE 788, we talked about this issue and we reviewed the legalities of it. It appears that in Nevada, in order to prepare, it has to be an appraisal of real estate, which may include improvements in fixtures. These types of properties, pipelines, are usually deemed personal property and are not treated as real estate typically. They're treated as unitary property. And so we did not believe it fit within that definition. We did note the provision that your counsel talked about, that if you testify in the state of Nevada or provide any testimony to the board that it's appropriate to be licensed. And we said, well, please make sure that you have your license if you're going to say anything to this board regarding your system value. And we asked them to do that and make sure that was in place. So if we have misread that, we apologize, but we believe we've complied with the requirements. And we believe that Mr. Hirscher and Mr. Cook complied with all typical USPAP requirements for doing a system assessment of a unitary property by being licensed in one of the states in which to determine that unit. So I just wanted to point that out and clarify a couple of those positions.
Thank you. Anything further from Tyree, Al, or Tim?
No,
Hearing
no,
none.
sir.
Hearing none, I'll turn it over to the Department of Taxation.
Thank you, Mr. Chairman. I did start by saying that Mr. John Schillo here performed the evaluation for Ruby Pipeline, and he did that according to the statute and regulation. Even more, we also are aware of intense discussions between the various departments of taxation and revenue within the states that through which Ruby Pipeline is going. And for the year ending December 31st, 2020, system values were very similar across.
Mr. Chairman, I'm sorry to interrupt, but the values from other states, whatever they may be, really aren't relevant here because the laws are different. I'm just, we want to go there.
Well, we will allow, under our procedures, we allow the testimony and then give it the weight that we believe that it deserves.
Thank you. Appreciate that.
So since it was mentioned that this is unitary evaluation, yes, we want to make sure that we verify with the other states, and we are in line with them. Even more, for the year ending December 31st, 2021, the value has just been certified last week. And again, we are very close in line with the other states. And this valuation, which is attached into, it is on, let me give you exhibit. Exhibit 8. No, sorry. Yes, it's Exhibit 8 that shows.
A State Board of Equalization page number would be helpful.
That would be State Board of Equalization number, sorry. SBE 1219. This one does show that actually the system value for this year dropped to half of what it was last year, which the other states did as well to reflect the current status of Ruby Pipeline. Now, regarding the issue presented at this hearing. Well, first of all, I understand that Mr. Crapo mentioned that they had no argument on the allocation. I see on their own direct appeal, they appealed three things. The third thing, number C, it says, department allocation factor of 47.3183 is erroneous and overstates the portion of the system value that is properly allocable in Nevada. Okay, now getting into the actual matter here, I think we have a timing issue. A timing issue relying on this impairment that we do not contest that it happened. Yes, it did happen. Now, Mr. Crapo referred to this as on a SEC document from Kinder Morgan showing that in 2019, Kinder Morgan, under 10K, recognized an impairment of 650. I do not see how that is relevant to the present case. However, what is relevant is on SBE 1121, which is the 10K for 2021 of Kinder Morgan, which says the impairment at Ruby was the result of upcoming contract expirations and additional uncertainty identified in late February 2021 regarding the proposed development of a third-party LNG exporting facility. And to be even more clear about the amount mentioned here, on the same 10K from Kinder Morgan for 2021, on page SBE 1126, it says, 2021 amounts include a non-cash impairment charge of 2.2 billion recorded by Ruby. The amount is exactly the one that has been disputed here as the impairment. But like I said, it appears to be a timing issue since the official SEC document states that it has been recognized in 2021 and not in 2020. Now, this is part of the due diligence that we did because by identifying the property as Ruby Pipeline, the most of the weight we put on documents coming directly from them, issued by them. In this case, since each and every company is supposed to send us an annual report and fill out the information to the best of their knowledge, I have here, I'm going to give you the number immediately. Exhibit 3, this is the annual report submitted by Ruby Pipeline on SBE 770. And this is the cost approach. On this table, you will see on line 20, write-downs and write-offs. This is where typically impairments would be entered. There is nothing. Going further, on Exhibit 6, on SBE page 776. Now, I know a company is not obligated to declare impairments to FERC, which is also a federal institution. However, stating over there in the middle of the page, just above revenue recognition, it says there were no impairments for the years ended December 31st, 2020 and 2019. So even if they were not required to report any impairment, they went one step ahead and stated that there were no impairments for those years. Now, I'm not going to go further with the licensing issue that was also noticed by us. I will still stay a little bit on the reporting. So Ruby Pipeline sent us, or we have access to, two types of reports submitted by them. The annual report submitted to us and the FERC report submitted to FERC. All the other information that became available was issued by third parties, whether it's an appraiser firm, whether it's PricewaterhouseCoopers, whether it's Kinder Morgan or PMB, but not themselves. So we rely heavier on what they say and also consider what the others say. Now, regarding the income approach, there were also some flaws detected, like, for example, revenue dropping dramatically while expenses would have just a slight decrease. This does not appear to be, and the source of the numbers appear to be a reliable income approach. However, for those aspects and further details, I will let Mr. John Shiloh here to continue with more details.
For the record, my name is John Shiloh. I'm a utility valuation analyst with the Department of Taxation, centrally assessed properties. I'll be brief with it. Began appraising commercial and industrial property in 1978. I was employed for 31 years with the New York State Department of Taxation and Finance. I appraised commercial and industrial real estate for advisory appraisals for municipalities and for equalization ratio studies throughout upstate New York. I was then employed with the Oregon Department of Revenue as an industrial real estate appraiser. After that, I was employed by the Stanislaus County Assessor in Modesto, California, as a commercial and industrial real estate appraiser. I've been with this department, the Nevada Department of Taxation, centrally assessed properties for 7 years as a utility valuation analyst. I'm assigned to value interstate electric companies and interstate pipelines. I've been a state certified general real estate appraiser for over 28 years. My Nevada State Certified General Real Estate Appraiser number is A.0207554-CG, which I held and have held before I appraised Ruby Pipeline. I'd like to state this, that I recognize this is a multi-state pipeline. I recognize it as real property, not personal property, because it's permanently affixed to the ground. It's 683 miles long. And that would be hard to identify it as personal property, which can be easily moved. And also, there's been a intent for permanence for this pipeline, which in the state of Nevada qualifies it as real property. I'm stating that I appraised this for property taxation in the state of Nevada. I did not present my appraisal on this pipeline in any of the other 3 states to contest their assessments. My appraisal is for Nevada. It will, the assessment will then be apportioned for the mileage within the state of that pipeline. I would like to, since it was brought up that there's 2 issues here, I would like to bring up the cost approach first on this. In the appraisal of real estate I'm referring to page 379, the 11th edition from the Appraisal Institute. It states, external obsolescence is a loss in value caused, which is past tense, by factors outside the subject property. All obsolescence for 2020 was recognized by the state of Nevada when it was reported in the centrally assessed property tax report from Ruby Pipeline and applied in the appraised value for the year ending 12/31/2020. So for 2 references, it's either on SBE 76 or SBE 720. In the cost approach that's presented in the appraisal by Mr. Herscher and Mr. Cook, it states an asset impairment or obsolescence of $2.2 billion. The amount is deducted from the cost to arrive at a value of $542,700,000. On page 393 of the Appraisal of Real Estate, 11th edition from the Appraisal Institute states, the method to estimate external obsolescence from rent loss or revenue loss is by a capitalization of the rent or revenue loss. The amount of 2.2 billion of external obsolescence should not be applied in 1 year. The amount is a loss of contracts. Ruby Pipeline did not expect to receive that revenue of 2.2 billion in 1 year. The asset impairment of 2.2 billion should not, well, I stated that. It was reported in the Kinder Morgan 10K for 2021. It wasn't reported in their Nevada real estate, real property report for 2020. If this 2.2 billion obsolescence is not deducted from the Ruby Pipe cost value, the cost value would be $2,743,909,256. The Nevada cost value is $2,724,994,146 from, which is noted on SBE 11. So they're very, very close without this single year deduction of $2.2 billion obsolescence, which hasn't been capitalized. I'd like to point out now to the income approach is that in NAC 361.423, number 3, it states the operating income to be capitalized into taxable income will be normalized and annualized based on the most recent year's adjusted net operating income. And number 5 states any normalization or annualization of adjustments to a company's net operating income must be based on known, measurable, and experienced changes in a company's operation. So it was not known in 2020 because Ruby Pipeline did not report it. And SBE 14, the Nevada Department of Taxation appraisal for Ruby Pipeline for the year ending December 31st, 2020, applied a capitalized average taxable income for the years 2018, 19, and 20, which was $150,242,919 to arrive at an income of $1,435,996,348. And SBE 98, quoting from the appraisal by Mr. Cook and Hersher, states the board should adopt Mr. Cook's and Hersher's income approach because it properly accounts for the expiration of ship and pay contracts. The department estimates the income to capitalize in its income approach by merely reviewing the income from the prior 3 years. This analysis is deficient because it fails to take into account the dramatic drop in revenue Ruby will experience as a result of shipper pay contracts that will expire in mid-2021. This was not on their property tax report for 2020. The department properly capitalized the taxable income because it appraised Ruby Pipeline for the year 2020. There was no dramatic drop in revenue that was reported by Ruby Pipeline. On SBE, page 71, the Cook and Hersher appraisal report in the first column states the revenue and expenses for the year 2021. There's no column for 2020, which is when I have stated the appraisal, their Nevada annual property tax report was issued. This appraisal fails to recognize the 2020 tax year. The appraisal report on SBE 71 projects decreasing revenue from 220.5 million in 21 to 89.5 million in 2026. That's a revenue decrease of 60%. The appraisal report, SBE 71, projects total expenses from 33 million in 2021 to 29 million in 2026, a 12% decrease. Why wouldn't the expenses also decrease at a similar amount over this same period? On SBE 15, the department appraisal has a taxable value of 150,242,919 for a capitalized income value of $1,435,966,348. On SBE 71, the 2021 net income is 148,323,300. That's very close to the department's 150 million. The Cook appraisal then applies discounted cash flow with a discounted factor of 0.95351 for a value of 545 million. I believe the discounted cash flow should not be applied to arrive at a reasonable value because it was applied to the years 2021 through 2026. This is not based on Ruby Pipeline's known, measurable, and experienced changes in the company's operation as of 2020, according to NAC 361.423, number 3 and 5. The Cook and Hersher appraisal report omitted the year 2020 on SBE 71 to justify applying an impairment of 2.2 billion omitted the year 2020, which wasn't reported until 2021, the Kinder Morgan 10K. I'd also like to state for the record that upon contacting the Nevada Division of Real Estate, they stated that a letter of engagement from out-of-state appraisers must be obtained from the Nevada Real Estate Division before an appraisal is done in Nevada. I didn't find this copy of a letter of engagement from Mr. Cook and Hersher. On SBE 33, it states the intended use of the report was for property tax matters for the 2021 tax year. The Department Appraisal Report is based on the 2020 tax year for the 2022 to 2023 tax year assessment. Anything regarding 2021 for this report is incorrect. And also on page SBE 28, the transmittal letter to Kinder Morgan from Cook and Hersher states also, the intended use of the appraisal is to assist in property matters for the 2021 tax year. I've also noted on pages SBE 88 and SBE 93, the professional licenses of Mr. Cook and Hersher are stated. In this report, neither have stated that they're Nevada State Certified General Appraisers or have temporary permits. This is a violation of NRS 645C.260 and NRS 645C.367, which refers to an issue of certificate, license, or permit to a resident of another state. I'd like to state that if Mr. Cook and Hersher intend for this appraisal report to have validity in this state, it stands to reason that they could both hold temporary state certified general licenses to defend this as of the time this appraisal report was written. Thank you.
Board, any questions or comments? Tim? I think everybody's muted.
I have none, Mr. Chairman.
Thank you, Al.
When the last gentleman from the department was speaking about the license, he referred to 361, 367. What was the other one that he referred to? That's a question for John. Question for John. He just testified that he didn't think they complied with the Nevada license. You referred to 361.367. You also referred to another license.
For the record, John Shillow.
And it was right at the end of your presentation. You said that it violated 361.367, and there was another one, 361. And I didn't catch that one.
NRS 645C.260 and NRS 645C.367. So the first one is 0.260. The second one is 0.367.
645C 260. Is that right?
Yes.
And 367. Okay, thank you.
Tyree, any questions or comments at this stage?
Mr. Chair, I'd be interested to know the appraiser, or excuse me, who just spoke, the presenter at the moment. What is the difference in between treating the pipeline as personal property versus real property, and why was that determination made? I understand the concept of it being affixed, but I would just be interested to hear an explanation as to why that decision was made.
Mr. John Shillo for the record. Well, personal property would be fixtures and stores that could be moved out. For instance, if the store was closing, it would be machinery that's not permanently affixed in a industrial plant that could be transported to a different plant or sold without big changes to the building. Those are two examples of what personal property would be. A pipeline or a fixture that goes through 4 states over 683 miles, there would be affixed to the ground, for instance, to prevent any damage from earthquakes, which we are present here in this state, but also prevents any movement. It also there would show an intent for permanence. So there's but it's when it was constructed in 2011, there was an intent for permanence. They hadn't planned to put it down and ship some gas and remove it within the year. Like it was going through it was in a campground or something where they're picking up their tents and moving. So those are 2 reasons why it's considered real property. Just as a
And so thank you, sir. I appreciate that. Is your approach different than that approach of that taken by the other 2? I will call them appraisers because they are appraisers, but you mean whether or not they have licenses in the state? That's debatable. So is that approach different than their approach?
For the record, I hope it wouldn't be. It would be similar to like a structure that with signal towers for cell towers or high tower high tension electric line structures that they're there to permanently help for the transmission of electricity or natural gas through their pipelines or their electric lines.
Okay, thank you.
And they're affixed to the ground so that, there's quite a bit of construction and structure that goes into affixing these to the ground.
Thank you for that clarification. No further questions from me at the moment, Mr. Chair.
John, I'd like to refer to page 1220 in the 1219 and 1220. I believe it's a summary of your analysis and valuations. Is that correct?
It's an SBE 1220.
1219 and 1220. Towards the very end of the package.
One, two.
Title at the top is Nevada Department of Taxation 23-24 tax year assessments.
Yes.
So the appeal at the very beginning fails to indicate what year the appeal is for, but I'm assuming that it's the
appeal. Jeff
Go ahead,
Mitchell, for the
please.
record, if I may clarify, the appeal is for the 2022, 2023 assessment as of December 31st, 2020. The document that you're referring to on SBE page 1219 and 1220, that is the upcoming years. That's a years later assessment.
Okay. So if I were to look at the 2020 income on page 1219 at 150,000 or 150 million, that's the income that would be applicable to this appeal? Is that, no?
No.
19's taxable income? If we were to look at it on a single year, please.
I can say a few things here. So for year ending December 31st, 2020, the income, the taxable income would be 150,242,919.
Okay.
Now,
and that's the year that we are addressing currently.
Exactly.
Okay.
The reason why we included this next year valuation that was certified last week was to demonstrate that we did take into consideration the current status of Ruby Pipeline and impairment and everything, and is being shown in the system value being dropped to half.
Okay. For the year in question, if you were to, we capitalized the single year's income, and what was that income figure? I apologize, the file was 1,200 pages and I've kind of lost track of where we were.
Going way back up.
So if we would, your question was that.
What year, if we were to use a single year's or if the income that you used to capitalize into perpetuity was an amalgamation of 3 years, what was that total? What was the number that you used?
Okay, I'll pull that up right now and we can go over.
I have it.
So, pipeline. Okay, I have it here. And right now, the one that has been certified was for 3 years average. And if we go with the 1 year only.
Well, no, I'm looking for the average that you used.
Oh, yes. The average that we used was 162,518,363.
162 million.
Yeah.
Sorry, yes.
An SB.
If I may, SB
69.
15 and 669 has
669.
What are those numbers again, Bob? What page are we on?
Page 6, 3 year, page 669, 668 and 669.
Actually, I'm looking on the revised one on 767 and 768. Where you would see, actually, 768 is the one that shows the three incomes for the 3 years, 2018, 2019, 2020. And below it shows the average.
It's the same document.
Yeah.
Yeah, they look, the numbers are the same.
Oh, okay, sorry.
And the overall capitalization rate you used for establishing your value?
11.3177%.
Okay, okay. Okay, any further questions for the Department of Taxation at this stage? Seeing none, Mr. Crapo. So what's going to happen is you'll have an opportunity to provide closing information, as will the Department of Taxation. We'll ask questions as is necessary. I'll close the meeting for deliberation, and then we'll do whatever we do.
Thank you. Appreciate it. Let me just comment on that page that you're on right now, the 669. If you look at the page right before it, the department is arguing that we have a timing issue. We don't agree with that. You'll see it right under the heading. It says this is for the year ending December 31st, 2020. Anything that's known, measurable, experienced by December 31st, 2020 should be considered in this assessment. We believe the department did not. And then going to the next page, if you look at this page, you're correct. You'll see in the middle, they took the last 3 years at 159, 177 on the far right in the middle taxable income, and 150. They took an average of that and did 162, and they capitalized it to come to their income approach of 1.4 billion. We say, their appraiser saying, well, you're trying to figure out what you're going to expect for 2021. They used a 3-year historical average to say, we think in 2021 to capitalize what someone would expect is 162 million. That's not correct. Everybody knew these contracts had been canceled. They already knew that there had been an impairment written on federal books, state books, and audited financials. Everyone knew it wasn't going to be that. As of that date, they knew those contracts had already been canceled. They hadn't been renewed. And the company was saying it's going to be 89 million, about 89 million. Lo and behold, what happened? They were spot on. And we gave you exhibit 17 at SBE 819, which is the 2021, the year after FERC form. And on that page, it shows the 89 million. The department should have made this adjustment for this tax year. They shouldn't have waited a year. That's our problem. They waited a year to make an adjustment they should have made previously. That's the argument. I want to hit just a couple of quick items. On the licensing issue, we refer you to our reply brief, SBE 788. We believe it was appropriate for these appraisers to do a unitary appraisal since they're licensed in one state. We've not been trying to deceive anybody. These are nationally recognized good appraisers. We think you should give weight to their appraisal, but even if you don't, you should remove the impairment from the division's cost approach of 2.2 billion, and you should use a more reasonable estimate of the income to capitalize in the income approach, and you're going to get to about the same number in the 500 million range. I want to answer the question on personal property. To the Commissioner Gray, it doesn't matter if this is personal property or real property for this assessment purposes. It's property, it's unitary property. The only reason I commented that it's personal property is these pipelines are regulated by the Interstate Commerce Act. They're almost treated uniformly throughout the country as personal property. There are some states that exempt personal property, and some of these pipelines don't pay any property tax because they're deemed personal property. You can quibble about it. It makes no difference for this appeal. The allocation issue is raised. We withdrew that in our briefing. That's not an issue. The thing that's really important here is there are audited financials, which is the exhibit that we gave you. Exhibit 4, SBE 329 is where it talks about. These are audited financials from Cooper Librant, dated as of the end of year, December 31st, 2020, which is our lien date. And on that page, they tell you exactly how they calculated the impairment based upon the old I don't know the ASC rule now, you can correct me, but the old FASB was 144. They followed a discounted and an undiscounted cash flow methodology. They don't like impairing their assets. They didn't want to have to do it, but they were required by the law to do it, and they did. It should be recognized. Now, the state pointed out on the FERC form, and they say the FERC form doesn't say there's an impairment. That's right. Regulatory books are different than FASB GAAP books. And if you look at SBE 167 for the FERC form, they make that very clear. The department said, well, there's no impairments. Well, on that page 167, they say there's significant differences between GAAP and the financial statements reported herein for the FERC form regulatory books. And what's the last statement, little 4? These financial statements, the regulatory statements, do not reflect impairments of long-lived assets or certain other adjustments that would be required by GAAP. So they tell you the GAAP impairment isn't reported here because it's not where you report it. The department asked the taxpayer to submit their annual return using the CFR accounts, the regulatory accounts. Now, more often than not, the regulatory accounts and the GAAP accounts don't differ too much. But when you have a major impairment and a write-down on an asset, they will. And that's what has occurred here. That's why the taxpayer wanted to do an appraisal, wanted to give it to the department. They gave it to every state and said, we've got problems, red flags, red flags. We're impaired. We're not going to earn this. Make sure we get a valuation that's appropriate. The department was fully on notice and they knew about it. Now to the 2021 10K of Kinder Morgan that the department referred to, saying, look at the 2.2 billion that's reported on this page. And I didn't write down the page. I believe it's 1126, I believe. 1126. That is in note 7. Note 7 is reporting the value of investments by all investors, whether it's Kinder Morgan, Pembina, or anybody else that has an investment. And they're talking about the equity investments. And what are they noting in there? They're just noting, saying, look, there was a write-down in 2020. All of us reported it in Pembina and Kinder Morgan. But now we're reporting the equity piece. And the audited financials usually come out in February, and 10Ks come out a couple months later. Rather than go restate the 2020 number, they're just saying, hey, the 2021 numbers are including this impairment that was already previously recognized by all the equity holders. So there's nothing unique about that, and it's a very unique and distinct area. So we've shown you audited financials that reported by the end of 2020, the impairment. We showed you the Kinder Morgan, which was data as of the end of 2020 impairment. We showed you Pembina, which showed the impairment by the end of 2020. It should have been recognized by the department. And I guess just the last thing on the income approach, because a couple points were raised, is, well, why didn't expenses decrease as much as the value? Remember, you've got a pipeline that's getting all these take-or-pay revenues. It's operating at about 40%. They hope to stay at about that 40%, which generates about 89 million that first year. Do you expect those expenses to really drop? In fact, with inflation, you're probably going to expect them to go up a little bit, even though revenue is dropping dramatically. Is there going to be a direct one-to-one ratio between the drop in value and the expenses? Absolutely not. It was appropriate under generally accepted appraisal practice. When you do an income approach, you can look at the past, the last 2 years, 3 years, 1 year, 5 years to try to estimate what an investor who's going to buy this thing is going to expect. Or you can look at forecasts from the company. In fact, that's expressly called out in the WSATA handbook, to which the department relies often, says look at forecasts. And they did. The forecasts here are better evidence of what's likely to happen than looking back at history when you know those contracts haven't been renewed. And so we believe that was the appropriate way, and the department should have done that. The very rules that the department relies upon, 361-408 and 361-423 say you may look at the last year. You may look at the third year. It does say you're supposed to normalize. Normalize what? Normalize the most recent year based on what you know. What does normalization mean? Normalization means you take out things that you don't think are likely to be repeated or come to pass in the future. You're not going to have this revenue. It should have been normalized for that. And under Rule 361-423 sub 5, it says any normalization, annualization, adjustments to the company's net operating income must be based on known, measurable, and experienced changes in the company's operation or taxable property as the current year reporting date. Current year reporting date, December 31st, 2020. Was it known these contracts were not renewed? Was it known that there'd already been an impairment? Had it already been experienced? All three of these elements are met. And the department should have made those adjustments. And it should have been done. And lastly, on reconciliation, Rule 361-429, subparagraph 4 says, the utility analyst will reconcile in writing to the taxpayer the facts, the trends, the observations developed in the analysis, and review the conclusion of the probable validity and reliability of the conclusions. If you look at the department's appraisal, their assessment, let me refer you to that. It's SBE 663. That's their original assessment that came out on July 7th, and then they revised it to adjust for some intangible property. Nowhere in that report do they provide this explanation. Nowhere do they say what's the trend, what's the observation, what's the likelihood of success of these numbers. Had they merely looked at the audited financials, the published 10Ks, and all the information been provided by the taxpayer, they couldn't reasonably have said their income approach or their cost approach were reliable or valid in any way, shape, or form. And so because of that, we believe this adjustment should be made for this tax year, the valuation year, December 31st, 2020. And we'd ask you to use your expert judgment. We think the appraisal is great evidence. If you choose not to put weight on it as an appraisal, we ask that you make the $2 billion adjustment to the division's cost approach and that you take their income down closer in the 89 range and capitalize it. You're going to come very close to the appraisal. So those are the comments we have. I'm happy to ask any questions or concerns you may have.
Can we refer back to page 1125?
Yes. Okay.
Can you clarify for me item C in the footnotes?
Okay.
Particularly the last clause that reads, and the year end December 19 loss includes a non-cash impairment charge of $650 million pre-tax related to our investment, see note 4.
Right.
We're talking about Ruby, and we're talking about, I believe this is Kinder Morgan's financial statement.
Correct.
The $650 million write-down represents Kinder Morgan's portion of the $2.2 billion impairment that it appears, based upon this footnote, was recognized in 2019. Am I interpreting that footnote correctly?
You're reading that correctly, and you are correct. The $650 million represents the equity piece for Kinder Morgan of the write-down of the $2.2 billion. And if
you say equity piece, that just is an allocation based upon their percentage ownership.
Correct.
Yeah.
And then if you look at the audited financials from PricewaterhouseCoopers, it's a 2-year Pricewaterhouse audited financial. So if you look at SB 317, it's for the years ended 2020 and 2019. Okay. For whatever reason, Kinder Morgan apparently wrote down internally their equity piece in this first, or even prior to Pembina in 2020. I'm going to be speculating. Kinder Morgan didn't have a guaranteed equity interest or a preferred equity interest like Pembina did for a buyout. So they had a bigger piece. So whatever reason, Kinder Morgan wrote theirs off first, thinking, hey, even in 2019, we're not going to get this. And so we're writing it down. And that's my understanding of what they did in that. Now, the other 117 that's in that footnote is what they still had left that they wrote down subsequently for a particular note. Did I get that right?
That's correct. Okay. Board, any questions or comments at this stage? This is our last opportunity to question the taxpayer. Tim.
I had another question about the, can you hear me okay, or?
We can.
Okay, we were discussing the ratio of the expenses, and the appraiser testified that he had examined those expenses and thought that they were reasonable and realistic based upon other properties that he had appraised, as I believe his answer was. And so I wanted to go back and ask him about what are those typical expense ratios for this type of property. And can you tell me what the expense ratios were historically for the last couple of years at the subject?
I believe that's a question for Mr. Herscher.
Yeah, Nathan.
Please, still available there.
I'm here. Sorry, just trying to get all unmuted and getting the getting my camera on. So sorry, Mr. Morris, will you repeat that question?
I believe that you testified when you were putting this income approach together that you looked at the historic expenses on a ratio basis and you felt that they were realistic and that you had compared them to other properties that you had appraised. I was wondering if you could tell me what those expense ratios are on the historical basis at the Ruby pipeline, and then what are the ratios that you used in this analysis?
So based on the historical from 2020 through 2026, those operating expense ratios, now keep in mind, these are just operating expenses without, they don't include depreciation and amortization, because in my analysis, I iterate that based on a buyer's basis, meaning a seller wouldn't, or a buyer wouldn't be able to take advantage of the seller's depreciation and amortization. They would, when they purchase the property, they're going to recalculate that. And so my point is so I'm looking at this subtotal figure. If let's see here, let me get on the right page on SB.
Well, let's look at
661
or
SB
691. 691. I'm looking at SB 691. Are you with me?
Let me get there to 691.
Yeah.
Okay, that's the same as SBE 47.
Correct. So I'm looking at just that subtotal figure. Okay.
Okay, so for 2020, you're looking at the 51.5 number.
Mm-hmm. Exactly. Okay. And so historically, those operating expense ratios were around the, they ranged from about 13 to 19%. Okay. Based on my calculations. And typically operating expense ratios are closer to the, 35 to 40% range. So actually using these take or pay contracts, these reservation payments, since they have higher revenues, these operating expenses are as a ratio are low. So meaning that it's actually, costing them less to operate it on a revenue basis because they have this inflated revenue amount from these take or pay contracts. Once you remove those in the forecasts, now looking at page SB, it's going to be on SB
71.
Yeah, 715, exactly. Those ratios, they start high because they're now in the there's still some bleed through of this high reservation payment. They're in the 15% range, but then they continue to increase as those take or pay contracts are removed to the 30 to 33% range. And that's more in line with, like I said, what I've seen with other pipelines.
So in 2021, what is that expense ratio?
I've got a 15%.
15%, but then you go to 27.8 and 30%,
Yeah,
30%,
and that's
26.
again, that's more in line with what I've seen. It's in actuality, it's still even a little on the light side. Those expenses on, compared to other pipelines could be higher, which would suggest a lower value. But again, I went with these because they're more in line with what I've seen with other pipelines.
Okay, so your first year in the DCF has a pretty high net income because your expense ratio's lower than typical. And that would kind of
And
indicate.
the reason why it's lower than typical is because we still have reservation payments, correct?
Yeah, the 218 million in reservation. So you have a lot more revenue in that first year. Okay, I understand that. The appraiser was questioning why you didn't use the 2020 income and expenses for the first year of your DCF. Did you understand that statement that he made?
I missed that question, I guess. Was that a point of contention made? He said that the expenses were understated?
No, he said that you in the DCF, you should have used the first year was 2020 instead of 2021.
Well, if my valuation date is end of 2020, I'm not going to capitalize income that's already existed. I'm forecasting into the future. And so I'm looking just at what's going to be realized from starting January 1, 2021 through my hold period, which is 5 years.
Yes, sir. That's what I thought you would answer. So I just wanted to clarify that for the appraiser from the state, that you don't start a DCF off with a historical year. You start the DCF with forecasting the next year, the first year. And then when you came up with your reversionary value, you capped the fifth year net income and added that to the proceeds of the 348 million for your residual value, right?
Correct.
Okay. But your first year net cash flow is 148 million, which is pretty close, I think, to their net income number, or a little bit less. They're using, 162 million, I think.
Are you looking at the next year assessment, I'm assuming? Do you have a SBE number on that?
No, I just wrote it down the notes when he was.
329, I think.
Sorry, say that again. So if I'm in
summary.
So at SBE 1220, that's for the year ending of December 31st, 2021. So it's going to have 2021 actuals. And if you look on that middle of that page, taxable income 2021, the taxable income was 89.6 million. And then if you refer back to my appraisal report on page SBE 715, I've got net income actually higher than that at 148,323.
Tim, to answer your question, the state used an income estimate of 162,518,000. as set forth on page 768 of the package.
Yeah, I saw the 162. So he's higher than the outside appraisers at
Yes.
148 million. Right, Nathan?
Yes.
Oh, so if I'm gonna add, so if I recall what's been done here, this is just averaging the 3-year historicals and not looking towards the future. Yes, it looks like the average of the 3 years historical is 162.5 million.
And you're using 148.
That was the first year, correct?
Yes.
Yes.
Okay.
But again, that 148 is for just that first year. As those reservation payments continue to roll off, that income decreases dramatically.
And then the expenses on a percentage basis, and the 30% are comparable to other properties that you've looked at and other 10Ks.
Correct.
And you have that all in your work file, I assume.
I do. I could provide that if you prefer, Mr. Morse.
I'm sorry, what's that?
It could be provided if you request, Mr. Morse.
No, that's okay. Somebody else might ask for that though, but I won't.
Okay.
I used to be on the appraisal commission, but not anymore. I'm finished, Mr. Chairman.
Thank you. Al, any questions?
Nope.
Kyrie?
Nothing from me at the moment.
Okay. It's back to the state for the closing discussion.
Thank you. Yeah, going over all these details gave me a clearer perspective here. But before I go there, I couldn't help but noticing that even ad valorem taxes on the table that we were just reviewing earlier.
What page are you looking at? I'm sorry.
715. So under circumstances when they ask a reduction of 70%, roughly speaking, the ad valorem taxes, which are property taxes for this value, just barely drops. So this is again inconsistent with the huge drop expected in, or not expected, but requested in value. Now, going back to the Kinder Morgan 10K for 2021, it's a document presented to SEC. I still believe that we cannot ignore that. The amount is exactly what was mentioned here for impairment, 2.2 billion. That's what we used actually for this year's valuation. John used it for the one that was used just at the end of the presentation here. And in conclusion, I would strongly recommend that we keep the values determined by the department.
Does it give you any pause that Ruby Pipeline recognized the impairment in 2019, which predates the date of value?
I noticed that was indeed mentioned, and we noticed during our due diligence as part of the 2019 year. We have not been informed about that. Now, my understanding here is that the 2.2 referred by Kinder Morgan in their 10K is separate from that 650. That's my perception.
That is inconsistent with what Mr. Crapro indicated, that the 650 is Kinder Morgan's a proportionate share of the $2.2 billion impairment.
I noticed that, but
it's not sequential. It's It's part of that number because of whatever their internal allocation of ownership is that Prima, what's the? Pembina would have recognized, and they did, the balance of the 1.4, the balance of 1.4 billion in their financial statements on whatever cycle is appropriate in Canada.
I understand. Now, I thought about that, but the issue that I'm having here is understanding why that's what Kinder Morgan says. The impairment at Ruby was the result of upcoming contract expirations and additional uncertainty identified in late February 2021. So if the issue was identified in late February 2021, I cannot imagine how come they could have done an impairment for this newly identified issue in 2019.
Although it is reported on their financial statement that they did.
My possible explanation.
Is it possible that that is a semantic difference where they recognized that the problem would exist in 2021, that that's the year that those contracts expired, recognizing, without regard to the date that they recognize that those are the dates that the contracts expire? Is it possible that that's a semantic issue or?
I don't know.
Because on their financial statements, they did recognize the loss in 2019.
I noticed that, and I consider that to be a loss identified at that time. And since I didn't see that connecting dots between that and this.
Okay. Okay.
Can I add something for the?
Please.
For the record, John Shillo. When I put a value on this for the year 2020 for the Ruby pipeline, I was appraising according to, as I've stated, NAC 361.423. Number 5, it has to be based on the company's net operating income on known, measurable, and experienced changes. As of 2020, first of all, it was not known because it was not reported on the Nevada real property tax report for 2020. Couldn't have been measurable, and they hadn't experienced it yet. It was recognized the following year when their report was submitted this year in 2022. I think that there has been some confusion because throughout the appraisal report that was submitted by Cook and Hersher, they keep referring to 2021. And they refer also that it was for the 2021 tax year. So from the beginning, there was an intention to say this was for 2021, ignoring what was reported for 2020 for Ruby Pipeline. That's what I was basing it on. In addition, I'd like to reiterate again that the cost approach was applied when they deducted the obsolescence of 2.2 billion. It was applied incorrectly. That it should not be taken in one single year because the Appraisal Institute, as I stated, it should have been capitalized. I don't believe Ruby Pipeline was expecting to receive 2.2 billion in revenue in a single year. Therefore, it can't be deducted. for that 1 year.
Yes.
That's all. Thank you.
Mr. Chairman?
Any further questions?
None for me.
Tyree? Hearing
None for
none.
me at the moment either.
I'll open up for a clarification, but your opportunity for testimony has come to an end.
I understand. I just wanted to clarify the last point on the write down in February of 2021. It's on SBE 1121. And that particular write down, it says during the first quarter of 2021, we recognize a pre-tax charge of 117 million related to our write down of our subordinated note receivable from our equity investee. What they're talking about in February 2021 is not the 2.2 billion. They're talking about writing off the last piece of the subordinated note of 117 million. That's what occurred in February of 2021. It was the actual write down of the assets in 2019 and 2020. That's the 2.2 billion. So I just didn't want the board to get confused on that.
Okay. At this point, I'm going to close the meeting for deliberations, but we are going to take a short break. It won't be a lunch break, but 15 minutes to stretch your fingers. Let everybody else do whatever they need to do for 15 minutes, and we'll re-adjourn and at about 1:20. Thank you. Okay, I'm reconvening the October 11th, 2022 State Board of Equalization hearing. We are on case 22-102. We are now into our deliberative phase. I'd like input from all of the board members. I'll start with Al Plank.
So I guess my observations are I'm a sucker for a good appraisal in our role. And we are talking about the income side of the equation versus the cost. I would be inclined to use the income approach value stated on SBE 76. I think it's in a couple other places, but in the appraisal itself, and use the income approach as calculated by the licensed appraisers. I don't know that the licensing issue would stop me from giving it the weight that it deserves. I tend to agree that it's a multi-state property, therefore the licensing becomes probably an interpretation issue, but I'd be inclined to go with the $545,100,000 valuation as calculated by the appraisers.
Does the data
under the income approach?
Al, does the data value as stated on the appraisal give you any pause?
No. No, I think with the write-off being recognized as early as 2019, I think there was a comment along the way somewhere too where their prediction looking forward was 89 million and they've hit it. I think under the definition of known and measurable facts used to generate the income approach, I think with that year lead time on the notification, they well knew what they were, what they weren't going to get when those contracts were going to expire a year later. In 2021.
Okay. Tim, I'll look to you next. Please unmute yourself if you would.
since Al brought it up about the licensing, I'll throw in my last two bits here. 645 C 260 talks about any person who in this state engages in the business of, acts in the capacity of, advertises or assumes to act as an appraiser without first obtaining appropriate certificate, license, or permit pursuant to this chapter, or an intern without first obtaining a registration card pursuant to this chapter, is guilty of a misdemeanor. So it doesn't say anything about where the other properties are concerned. It's talking about what is done in the state of Nevada. And there's an appraisal of property located in the state of Nevada that's identified in the appraisal. And I think that there should have been a temporary permit acquired by these individual appraisers. As far as the valuation, I'm still working on that. I want to hear from you, Bob.
I'm going to allow myself to go last. I'm going to ask for Tyree's input next.
Thank you, Mr. Chair. Tyree Gray here. I believe this is a sophisticated operator, and what we've seen today is an appraisal that's been brought forward. Similar to Al, I'm a sucker for a good appraisal as well. With the understanding that what the company has articulated has come to fruition, has come to pass. And so, I mean, all appraisals are snapping, I mean, a photo, if you will, in time. And so I'm compelled that an adjustment should transpire. I am not exactly sure how to calculate that, but I will, let me be the first to say that I believe that an adjustment is, in my opinion, is warranted based upon the facts that have been laid out today.
Okay, thanks, Tyree. My thoughts are similar. I think that even completely, I am of the opinion, and it's merely my interpretation, that in a unitary property such as this that crosses multiple states, that having a license in one of the states may be adequate. I look to an example, if you were to try to value the landlines for AT&T throughout the US, I don't think that you would be required to have appraisal licenses in all 50 states and the multiple countries that AT&T touches. I think that they're addressing them, their involvement, because they are licensed in one of the states that this property crosses. If they were a New York or a Texas or some appraisal firm that had no connection with the property, any of the venues that this property operated, in my opinion, would be different. But that notwithstanding, even if we completely discount the information that's in the appraisal, the impairment is discussed elsewhere in the documentation that's provided, and there's no requirement that documentation be produced by Nevada residing professionals. It's presented in the Ruby Pipeline financial statement, wherein they discuss an impairment dating back to 2021 or 20 in the Kidder Morgan financial statement, where they discuss the impairment and their acknowledgement of the impairment in 2019, predating the date of value. Bless you, Al. The argument, I think, is compelling that the impact of the expiration of these take and pay contracts was easily anticipated and probably could have been anticipated as long ago as 5 or 6 years ago, that as volumes of actual product transmitted remained unchanged over time, that the take or pay contract, the option to fill this pipeline, is really an unnecessary expense on the part of the producers. There does not appear to be a situation that could be envisioned even as long ago as 5 years ago that this pipeline would have such a change in demand that there would not be space available. And so I think that the anticipation of the expiration of these contracts could have been anticipated long ago, probably contemporary with the discovery of the other gas fields. Regarding the calculation of the obsolescence or impairment, well, I did not do it. If you do a discounted cash flow on the remaining income and it results in a reduction in value, it would make sense that if you discounted the income that was lost, the other side of the equation, that the calculation would be similar. And so while we didn't discount the lost income, or we didn't capitalize the lost income, I would suspect, based upon having done this a number of times elsewhere, that the calculation of the lost income, the value of that lost income would have resulted in a very similar number. This is further acknowledged by the fact that the state acknowledges this exact obsolescence in their 2021-22 estimate of the taxable value. They reduce their taxable income projection to $89 million and acknowledge and accept the $2.2 million or billion dollar impairment for the coming year. So as everybody has stated, it seems to me that it is a timing issue, not necessarily an issue of the method of calculation. I think that publicly available information, in my view, suggests that the participants, the owners of this property, really did acknowledge and disclose the impairment in a timely fashion, in a fashion that would affect the taxable value in the tax year at question. And so, you know, I would not be opposed to a motion that reduces the taxable value of the entire system, and by virtue of that, the allocation to the state of Nevada. Those are my thoughts. So at this point, if somebody would want to add any comment or make a motion, I would entertain either. Tim, you're muted if you're trying to say something.
Okay, so if we're looking at you're giving more weight to the DCF or just a straight capitalization of net income? What do you think is more appropriate here to value it? I know we can't spread out a DCF real quick and throw that on here, but we're looking at a EBITDA in 2021 of 187 million. And I don't think we should capitalize that number. It's declined so much in the next several years. We could adjust a cap rate for that. But what are your thoughts on an appropriate net income?
Well, I think, Tim, the statute really, I think, if I've interpreted the notes that I've received from Jeff correctly, the statute doesn't really allow us to use a DCF. I think what we might in alternative lean into is that we are still constrained not to exceed the full cash value. And I think that if you combine the recognition of the $2.2 billion impairment along with the bankruptcy of the Ruby Pipeline and anticipated auction of the assets, the impairment, the reduction in the taxable value by the impairment may approximate the market value. The impairment was based upon a recognition of lost or a significant reduction of income. And so I'm not sure that at this stage for this tax year, capitalizing an income and then adding back so if we, as an example, if we capitalize the $89 million that the state is using for the 21 tax year, we would then have to add back some income for the interim year where the take or pay contracts, some of them have not expired. So that would be adding back $50 million or so in value to that number as additional income. That might be a way to get to the number that you're looking at. We can look at page, I think it was 125, maybe 1125. Nope.
What are you looking for? The DC?
The state's calculation of the 2021 taxes, taxable value. Look at 1219 and 1220.
Okay, so I'm on 1220.
So they, on 1220 for the 21 tax year, they've capitalized $89,644,469 as their stabilized income at 11.3967, come up with a value of system value. I believe it's a system value. The system value?
Yes. So that's the income approach system value, and then the reconciliation
Is at the top. They come up with a system value of $786,582,000 that's then reconciled to a Nevada allocation of something less. If we were to use that same calculation for the 2020 tax year, we would have to add back in the additional bonus income, the difference between rounded 90 million and 150 million, or approximately $60 million to the system value. System reconciliation. So that would bring that $402 million Nevada allocation value. Bear with me just a moment.
Well, you're trying to use the taxable income of 150 million then?
No, I'm trying to recognize that we have a very firm feeling as to what the stabilized income of this property would be. And we've got a bonus income in the first year of in the current tax year that is not expected to be repeated.
Okay, so from you're talking about the 786 million and then just deducting a bonus income of 60 million. So
no, adding back the bonus income, because the $786 million is calculated based upon an income of 89,644,000, where 2020's income was or is 150 million.
So if we take this 786 million and add roughly 60 million to that, that's where you're going to be at somewhere around 800 million.
Yes, well, 840 million. 850 million. And then make that allocation 47.3188% to Nevada.
Yeah, I thought it was like 46.9%.
System to Nevada book, I'm on page 1219. In number 2, system to Nevada allocation, system to Nevada book cost is 87.3188%. Do you see that, Tim?
Okay, I'm on page 1219.
Yes, about 8 lines down. Third line in the number 2, system to Nevada book allocation,
Yeah, 47%.
47.3188%.
Okay.
And then the additional, I'm going to call it bonus income, is the difference between 150 million, 1502, 42919, and 89, 4 minus. So the bonus income is $660,598,450, which is the difference between 2020 and 2021. 47.3188% is 28,674,459. 2,209,800. So using those calculations, my calculations resulted in an allocation for the Nevada portion of the system of $430,884,259.
I got a different number. What is the number you got?
430,884,259, which is the Nevada's allocation from the 2021 calculations on page 1219, plus a proportion of the $60,598,000 bonus income for 2020.
I'm sorry, where did you start on 1220? What's the first number?
I'm looking at 1219, and I'm starting with 402,209,800, which is the Nevada value allocation.
Item number 3.
The very bottom of item number 2.
Okay.
And to that, I've added 47% of the bonus income, which is on page 1220. And I've calculated the bonus income is the difference between 2020's income of 150,242,000 and 2021's income estimate of 89,644,000. That difference being in aggregate $60,598,450. 47.3188% of that is 28,674,459. So I've added that